I haven't. You look so good. And then I have one this upcoming Sunday.
There's a fair amount of stuff in sort of stuff as such, and clearly a lot of the statements that are along
We'll see.
It was really, I had really forgotten how much rhetoric and sort of way she was thinking about these things throughout her name.
All right, we're going to go ahead and get started. Good morning, everybody. I'm Michael Scharf. I'm the co-dean of the law school. It is my great pleasure to welcome everybody to today's Law Review Symposium. This symposium is our annual Law Review Symposium, and this year it focuses on First Amendment issues in education. This is a topic that is especially important to me, as my own decision to become a lawyer was made in the context of what I considered to be an unjust infringement of my First Amendment rights when I was in high school. So I'm going to begin by telling you a story back in time to the year 1980. At that time, I was the editorial page editor of the Shakerite newspaper from Shaker Heights Public High School just up the road. And my dream in life was to become an investigative journalist. And so I was hoping that I could create a portfolio of investigative stories about the high school that I was publishing that would someday get me into a good college and land me that first all-important job. So a couple of weeks into the first semester in this position, I was sitting in a classroom in the first floor of the high school, and I noticed that there were pipes throughout the classroom running vertically, and people had scratched off the coating of the pipes, and other people thought it was fun to pound the pipes every so often and allow a big cloud of white dust to float around. So I went to my science teacher and I took a sample of this, and he said, yes, this is what I thought, it's asbestos. And at that time, asbestos was not prohibited, but there were a lot of studies saying that it was going to be dangerous and that there should be something done about that. And I was also on the debate team, and the topic that year happened to be consumer product safety. So I was reading those studies. So I decided to write an article under the rather edgy title of "Our High School May Be Killing Us." So the article comes out. The next day, the principal calls me down, and this guy's name was Mr. Warren Zimmerman. And so Mr. Zimmerman says, Michael Scharf, all day long I've been on the phone with irate parents who are very upset about your article. And then I've been talking to irate school board members, and I just got off the phone with the superintendent of the schools, and he was really upset. He says, we have a real problem, and I'm going to do something about it. And I'm thinking, that's great. My first really important article has changed the world. And he says, so you are the problem, and what I've decided to do is make sure that you never write for our school newspaper again. So he threw me off the school newspaper and he banned me from writing. I went home to my parents and I said, we've got to do something about this. This is unjust, and it's going to alter the trajectory of my life. Little did I know. And my mother, who's a social worker, said, oh, honey. My dad, who was a businessman, said, do you really want to make this a big deal? Neither of them knew any lawyers, and they certainly didn't want to bring a expensive litigation on my behalf. So they just convinced me I couldn't do anything about it, and I was dejected, and I focused on other things. But it really made me decide that I wanted to go into law because it felt unjust. And in fact, I will tell you this. Every time I write a book or an article, and I've written over 100 articles and 20 books, 6 of which have won national book awards, I channel that feeling of unjustness that I felt at that time, and that gets me through the writing of these large pieces. Those of you on law journals, if you need to write a long note or something, find something that you're really that passionate about. But I don't know whether if we had brought that case, it would have succeeded in the courts. Back then, the jurisprudence was different than it is now, and I know that over the years, it's become harder and harder to win a case like that. But maybe with that case, things would have been different. Anyway, I ended up becoming a lawyer, a law professor, and now for the last 9 years, the dean of this law school. And I am really glad that the Law Review has chosen this particular topic for our symposium. Today's symposium will discuss current First Amendment issues in lower and higher education, recent state legislation, circuit court and Supreme Court decisions, and social movements have impacted our American educational system. And today we have an opportunity to discuss these issues as they have become more timely, well-known, and important than ever before. Today's event will provide a look into topics such as academic freedom protections for teachers, K-12 curriculum and school choice, off-campus speech, critical race theory, and student mistreatment. We will also discuss practical considerations of recent legal developments with practitioners in the education law and free speech areas. Our event today features some of the leading scholars in these practice areas from around the country. We would like to thank the Stanton Foundation and the Attorney Admissions Fund of the U.S. District Court for the Northern District of Ohio for providing support that enabled us to put on this symposium. I'm now happy to turn it over to Kennedy Dixon, the Executive Symposium Editor, for an overview of the day's schedule. I hope everybody has a great time. It's going to be a great symposium. Thank you.
Thank you, Dean Sharp, and thank you all for coming today. I want to briefly talk about why I picked this topic for our symposium. Personally, I'm eternally grateful to all the educators that have played a central role in my life. They've instilled a love of learning that I hope inspire and guide our conversations today. In my family, my grandfather was a high school teacher for almost 40 years. And my father, who's here today, has served as a university professor for over 30 years. More broadly, the First Amendment safeguards the right of every person to speak and think freely. These rights are at the heart of the educational process. But rapid social, legal, legislative, and even technological changes have escalated controversy in our American educational system. The limits of the First Amendment protections are being challenged in the classroom for teachers and students alike. As law students and lawyers, this topic is of the utmost importance because we serve as the arbiters tasked with representing individuals in the resolution of these tensions. Our role is to help define the critical rights and responsibilities of participants in the educational process. With that said, I would like to take a minute to thank our moderators and speakers for making time for this program today. We are so excited to hear your thoughts, engage in conversation, and publish some of you in the spring. I would also like to thank a few people who have been instrumental in making this program happen. First, Mr. Eric Seiler, who handled all of our logistical and travel arrangements for today. I would also like to thank our executive board for being supportive of my ideas in making this program happen, and as well as all of our associate editor volunteers for helping me out today. Thank you to Professor Adler, Professor Hill, and Professor Hardaway, as they all helped in the early planning stages by reaching out to speakers and providing guidance to our overall program. And of course, Professor Enton, our Law Review faculty advisor, has been a constant source of guidance and help with finding funding, speakers, and answering any questions that I might have. Today's schedule includes two main panels. Professor Jaffe will lead the first panel, which will cover K-12 First Amendment considerations for students, teachers, and parents. Then we will have a break for lunch. Then at 1 o'clock, we will reconvene for a second panel led by Andrew Geronimo, our First Amendment clinic. He runs our First Amendment clinic. We will discuss academic freedom more broadly and student mistreatment in the context of higher education. So without further ado, I'll turn it over to Professor Jaffe to begin our first panel. Thank you.
Thank you,
Kennedy. I'm Dan Jaffe, and I teach education law here at the law school. I also co-author a practical treatise on education law in Ohio, and it's my honor to be the moderator for this distinguished panel. And I'll take a few moments to say a few words. I will introduce each speaker as we go, so that you can remember who they are. And if you would hold your questions until all the speakers are done, we'll have adequate time for questions and answers. So, so with that said, let's remember why we're here, and I'll pull out my Constitution. And the First Amendment says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people to peaceably assemble and to petition the government for a redress of grievances. So, how did this get involved in primary and secondary education? Because while the need for universal education was generally recognized by the founding fathers, in practice at that time, there was no general education requirement. So in his farewell address in 1796, George Washington said that we must promote as an object of primary importance institutions for the general diffusion of knowledge in proportion as the structure of government gives force to public opinion. It is essential that public opinion should be enlightened. And Adams wrote, the whole people must take upon themselves the education of the whole people and must be willing to bear the expenses of it. And yet at that time, there really was no public education. There was private education for the wealthy through private schools and religious schools. Thomas Jefferson put forth a plan in Virginia for general public education paid for by public funds twice, and twice it was rejected. Turning to the 19th century and looking here in Ohio, Ohio gained statehood in 1803, and it wasn't until 1825 that the very first tax was enacted for public education, at that time only for buildings. By 1836, there were 468,000 school-age children in Ohio. Of those, 322,000 attended less than 2 months, if at all. At that time, the Common Schools movement was spreading throughout the nation, pioneered by Horace Mann in Massachusetts, and indeed it came to Ohio as well. And in Ohio in 1839, there were 455,000 students attending school, and yet only 7% of high school age students attended high school. By 1970, that was 94%, and it was in 1851 that the Ohio Constitution first provided for a system of education. Along the way, the First Amendment received significant interpretation by the U.S. Supreme Court. While not explicitly on First Amendment grounds, I'll take you through a couple brief landmarks. 1925 was the Pierce v. Society of Sisters case, which established the basic split, the compromise between public education and the state's right to require public education and parents' rights to direct their education, setting up the system of public schools versus private schools. In 1943, the First Amendment came to schools with the West Virginia v. Barnett case, and Justice Jackson's famous words, "If there's any fixed star in our constitutional constellation, it is that no official, high or petty, can prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion, or force citizens to confess by word or act their faith therein. 1969 was the Tinker case that said that students do not shed their constitutional rights at the schoolhouse gate. And in 1985 was the Wallace v. Jaffrey case that overturned a mandatory moment of silence on establishment grounds under the Lemon v. Kurtzman test. Fast forward 2002, the Cleveland School voucher case, finding that a voucher system that allowed for private religious educational institutions to participate did not violate the Establishment Clause. And fast forward to the current era, the 2021 Mahanoy v. BL case, setting some parameters for where the schoolhouse gate is in the internet era. And just this year, Carson v. Macon saying not only is it permitted to have a voucher system that includes religious schools, once you have your voucher system, you cannot exclude religious schools. And finally, the Kennedy v. Bremerton case, announcing the demise of the Lemon test and showing that, and establishing that history and coercion are the important factors when we consider establishment cases. In the meantime, schools and the law related to schools is in a state of some disarray. So I'll talk very briefly about Ohio. We have statewide vouchers for private and religious schools. We have charter schools, including online charter schools. We have fights at the State Board of Education, which first passed a resolution condemning racism and white supremacy, and then repealed it in favor of one condemning teachings that seek to divide. We have fights at local school boards over curriculum and masks, and I'd say all in all, we are in a period of upheaval, all of which our speakers will certainly straighten out for us. Right, Tammy? Okay, so let's start with Professor Richard Duncan. Professor Duncan joined the Nebraska Law School faculty in 1979. He's a graduate of Cornell Law School, where he served on the board of editors of the Cornell Law Review. Professor Duncan teaches property, constitutional law, and First Amendment. He is a passionate and enthusiastic classroom teacher whose style is not so much Socratic dialogue as Socratic performance. I'm sorry, Socratic performance art. He spends most of his passion and energy teaching, writing, and speaking about issues such as right to life, religious liberty, freedom of speech, the pursuit of happiness, and other inalienable rights and liberties. Professor Duncan's talk is entitled "Education is not value-free. Indeed, it is value-laden. And in a country as divided as ours, we no longer have common values and common truths. We have competing versions of what is good, what is true, what is fair, what is just, what is morally good, and what is beautiful, not to mention whether God exists and whether God's word is relevant to a quality education. And a one-size-fits-all K-12 curriculum cannot serve both or all versions of the good life. His topic is why school choice is essential for religious liberty and freedom of thought and belief formation. Professor Duncan.
I'll spare you the performance art.
We want to see that.
Okay, so I'm really happy to be here. This is an incredibly good symposium with a number of speakers who are first rate in their areas, and I'm just happy to be one among many really good scholars and practitioners in this area. So my topic is basically why school choice is necessary for religious liberty and freedom of speech and belief formation. Now, although I think competition is always good for the quality and efficiency of any product or service, my argument today is not about higher standardized test scores or better mastery of subjects and skills. My perspective is based upon First Amendment values of freedom of religion, thought, and belief formation. In other words, I believe that school choice is necessary for religious liberty and freedom of thought and belief, just as it violates the letter and spirit of the First Amendment to directly compel all K through 12 school children to attend public schools. I argue that it also violates the letter and spirit of the First Amendment when states create a funding monopoly that de facto compels impressionable children to attend government schools, where they are taught the content and viewpoints chosen by government officials who control the curriculum of the public schools. So if intellectual and religious autonomy are to flourish in a deeply divided, pluralistic nation such as ours, parents must be free to choose an appropriate education for their children without having to sacrifice the benefit of public funding of education. To put it succinctly, educational funds should be directed to children and their parents, not to strictly secular government schools. Now, I'm no Pollyanna. I am not here to argue that existing constitutional doctrine requires public funding of school choice for families who choose to avoid educating their children in government schools. Indeed, as recently as June of this year, the Supreme Court made clear in Carson versus Macon that the states are under no obligation to subsidize private schools, and the court also made clear that the states are free, quoting the court, to provide a strictly secular education in the public schools. So my purpose here is simply to point out that if we take seriously the constitutional ideal of parental rights and neutral pluralism of religion and belief under the First Amendment, the case for equitable funding of school choice for all children is compelling, both the policy case and I think the constitutional case. Now, there are 3 lines of SCOTUS cases that all point towards a right to equal funding for school choice. Mayer versus Nebraska and Pierce versus Society of Sisters make clear that parents have a fundamental substantive due process right to control and direct the education of their children. Thus, a law requiring all children to be educated in government schools is unconstitutional. And the court explained its holding in Pierce with an iconic defense of pluralism and freedom of belief formation that resonates more than ever today. The fundamental theory, said the court, of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. Those who nurture him and direct his destiny, that is, parents, have the right, coupled with the high duty, to recognize and prepare him for additional obligations. Now, although this right of parents was recognized by the court in 1925 as arising under the Due Process Clause of the 14th Amendment, in his opinion for the court in 1965 in Griswold versus Connecticut, the contraception case, Justice Douglas declared, this is dictum, but Justice Douglas declared that the right of parents to educate a child outside the public schools in a school of the parent's choice is perhaps best understood as arising under the First Amendment. As Douglas put it, the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge by forbidding education outside the public schools. In other words, the First Amendment guarantees the right of parents to protect their children's right to freedom of thought and belief formation from being standardized by laws restricting these rights, by laws that either in fact directly or indirectly compel children to attend public schools. Now, under the Free Speech Clause, so that's substantive due process and sort of being reimagined as a First Amendment right. Under the Free Speech Clause, the government school monopoly is a brutally coercive system that creates a captive audience of children for compelled educative speech in the content and viewpoints of curriculum chosen by government officials. And this is at odds with established First Amendment doctrines forbidding both compelled speech and content and viewpoint discrimination. And the monopoly also violates at least the spirit of recent free exercise cases, such as Trinity Lutheran, Espinoza, and Carson versus Macon, that made clear that laws that fund secular benefits, such as subsidies for daycare and scholarships for private K-12 education, are unconstitutional if they exclude similar benefits for religious institutions and families. It's Chief Justice Roberts, and Justice Roberts usually kind of speaks with a quiet voice, with a gentle voice, but he spoke very clearly and strongly in this case. As he put it so clearly in Espinoza, the K-12 scholarship case for private schools, the First Amendment condemns discrimination against religious schools and the families whose children attend them. They are members of the community too, and their exclusion from the scholarship program here is odious to our Constitution and cannot stand. And what I want to do with the rest of my time today is to demonstrate that the monopoly of funding is a brutally coercive denial of these fundamental First Amendment rights involving educational freedom and equality. It effectively forces parents to accept instruction, kind of echoing the Pierce opinion. It effectively forces parents to accept instruction for their children from public school teachers only. Now, I have a progressive colleague. I have many progressive colleagues, but I have one progressive colleague in particular who tells me that lived experience is not debatable. Well, I concur in part and dissent in part. I believe that lived experience, although always debatable, often sheds valuable light on important issues of law and social justice. And school choice, the funding of students and their families rather than government school systems, is one such issue of fundamental importance in contemporary America. So allow me to share some of my lived experience as a person of faith and a father of five concerning educating our children in an increasingly secular and increasingly divided nation. A number of years ago, I was asked to speak to a large young parent Sunday school class at a large evangelical church in Lincoln, Nebraska, where I live. And the pastor who invited me wanted me to help these young Christian parents think through their options for educating their children, public schools or private religious schools. So on the scheduled date I walked in, a bit of a wise guy, I walked into the room and explained that since I'm a law professor, I ask questions rather than answer them. So I asked several questions. My first question went like this: how many of you young Christian parents wish to educate your children in a curriculum that reflects the mind of Christ? Now, how many of these parents do you think raised their hand? Of course, every one of these loving parents quickly raised his or her hand. Then I asked maybe some of it was virtue signaling, but then I asked my second question. How many of you believe that the public school curriculum reflects the mind of Christ? So now how many do you think raised their hand? Of course, not one hand was raised in response to that question. And for my third question, I pretended to be confused, sort of went into my Detective Columbo shtick and said, I'm going to have to go home and ask Mrs. Columbo about this because I'm very confused. I said, why did you invite me here to help you think through your decision if you have already decided that the public schools are not appropriate to the education of your children? And in frustration, many of these just young Christian parents exclaimed, and you know what they exclaimed, but we cannot afford to send our children to private religious schools. Ah, there's the rub. We hear a lot about systemic inequality lately, but there is no greater systemic inequality than an educational funding system that provides a K-12 education only for those who wish a progressive secular education for their children in the public schools. The selective funding of education in secular government schools guarantees religious inequality in America. It imposes on religious parents what even supporters of public schools call a brutal bargain. Religious parents must choose between the single largest benefit most families receive from local government and their right to educate their children outside the government schools. In my lived experience, the government school monopoly is a brutal bargain indeed. It was a brutal hit for my family's finances, and I've been blessed with a law professor's income, so I don't really worry about people like me. How much more brutal is it for parents trying to raise large families on a lower working class income? The poorer the family, the more brutal the coercion of the monopoly. But here's the math for someone like me, a Christian father of 5 children for whom a secular progressive curriculum is inappropriate for my children because it undermines much of what my wife and I believe about things in life that matter a great deal and things that we think our children ought to be taught. Now, in my home state of Nebraska, the average per pupil funding for K through 12 education is a little over $13,000 per year. So $13,000 times 5 children times 13 years. Let me do that math in my head real quick. No, I've got it written down here. $845,000. That is the penalty someone like me would pay for educating their children in private religious schools. If you send them to the government schools, you get $845,000 for your children's K through 12 education. If you enroll your children in private religious schools, you lose every penny. That is a brutal bargain indeed. The combination of mandatory attendance laws plus the educational funding monopoly for government schools guarantees a captive audience for the so-called common values, viewpoints, and knowledge selected by state legislatures, local school boards, and other government administrators and officials, and the interest groups that lobby them as well. Moreover, the Supreme Court's Establishment Clause jurisprudence strictly forbids any curriculum in the public schools that encourages or endorses religious ideas or values. Thus, the public school system is not and cannot be a religiously neutral system of education, neutral between religion and non-religion. The public school curriculum is an engine of secularization. Professor Michael McConnell captured the hopelessness of religious parents when he observed, a secular school does not necessarily produce atheists, but it produces young adults who inevitably think of religion as extraneous to the real world of intellectual inquiry, if they think of religion at all. The focus is constantly on a secular perspective, a secular understanding of everything that comes up in a typical school day. And perhaps no one has understood more clearly this reality concerning the government school monopoly than John Stuart Mill, who put it this way in 1859 in his iconic treatise on liberty. All that has been said, says Mill, of the importance of individuality of character and diversity in opinions and modes of conduct involves, as of the same unspeakable importance, diversity of education. A general state education is a mere contrivance for molding people to be exactly like one another. And as the mold in which it casts them is that which pleases the predominant power in the government, whether this be a monarch, a priesthood, an aristocracy, or the majority of the existing generation, in proportion as it is efficient and successful, it establishes a despotism over the mind, leading by natural tendency to one over the body. Despotism over the mind, says Mill. Instead of schools run by government, Mill supported what he called diversity of education and parental choice. So I think we need to ask a few questions in deciding whether the government school monopoly is consistent with at least the spirit, and I think even the letter, of the First Amendment. Since time is short, here in a nutshell is my take. I fully realize that as recently as this past summer, the Supreme Court has made clear, at least in its dictum, that a government may adopt a strictly secular curriculum in the public schools and has no obligation to fund private K through 12 schools. So at least for the foreseeable future, the Supreme Court's First Amendment doctrine will not relieve parents of the brutal bargain imposed on them by the government school monopoly. However, this coercive take-it-or-leave-it system of funding education is inconsistent with both the letter and the spirit of the Free Speech Clause and the Free Exercise Clause. As Mill observed, it results in a despotism over the hearts and minds of our children and eradicates the rights of parents to control the education of their children. It violates the spirit of freedom of speech by forcing parents to substitute the preferred viewpoints of government officials for their own, concerning fundamentally important ideas about history, government, justice, sexuality, gender identity, and many other topics arising in the course of the K through 12 education. Moreover, because the government school curriculum is strictly secular and is required to be under Supreme Court case law, this funding monopoly inherently forces religious parents to choose between their faith, think about the parents in the Sunday school class that I mentioned, forces religious parents to choose between their faith and their ability to educate their children as they think best. Such religious discrimination is odious to both the letter and the spirit of the free exercise clause. So let me just close with this. Some would argue that school choice results in non-believers being taxed to fund religious education for believers, and that this is unfair to non-believers. Well, is that true? Is equal funding for every child's education somehow preferential funding of religion? Unlike public schools, which, as we have seen, are most definitely not neutral between religion and non-religion, and I have no beef with the public schools. If the people they work for, there's a lot of wonderful professionals who teach and administer in the public schools. I don't have a beef with them. I'm just saying they're not for everybody. So unlike public schools, which we have seen are most definitely not neutral between religion and non-religion, school choice for each child is strictly neutral because everyone, regardless of their religious or non-religious views, gets equal K through 12 funding. Indeed, Michael McConnell and Richard Posner take the position that equal funding of school choice is necessary for neutrality and systematic equality. They explain the economic impact of school choice this way. No one is taxed to support the religious education of another. Rather, each person pays one lifetime's worth of taxes earmarked for education and in return receives in advance one education. Of course, things would not work out as neatly in practice as they do in this very abstract model. There would still be a subsidy from rich to poor, but there would be no systematic transfer of wealth from individuals who attend religious schools to those who do not. On the contrary, to force individuals to pay educational taxes, but deny them education financing because they have chosen a religious school brings about a systematic transfer of wealth from the religious to the non-religious. And if my math is correct, it is a large transfer of wealth. So what they're saying basically is rather than focus on parents paying school taxes, the focus should be on each child. Each child gets one free K through 12 education in a public or private school of the family's choice, much like a school loan. And each child pays a lifetime of taxes to repay that loan. Everyone gets one, and everyone pays for one. Secular citizens do not subsidize religious citizens, and religious citizens do not subsidize secular citizens. At one time, a neutral school choice program that included private religious schools would have been struck down as a violation of the extra-constitutional wall of separation metaphor. But today it is abundantly clear that a neutral school choice program funding both secular and religious private schools is valid under the Establishment Clause. Of course, the Cleveland school choice case, Zellman versus Simmons-Harris, in which the court voted to uphold a school voucher program that involves true private choice and provided neutral educational assistance directly to a broad class of individuals, defined without reference to religion, is the leading case, but the court has said the same thing time and again since then. In other words, states may fund private school choice programs if they wish to do so. The important question for the courts to decide today is whether the First Amendment requires states to fund all K through 12 educational choices. School choice, by the way, may also be the solution to the public school curriculum wars that are taking place across the country today. In a pluralistic and deeply divided nation, such as America in 2022, a one-size-fits-all curriculum is doomed to fail and to deeply politicize the public schools. A one-size-fits-all curriculum, especially one covering issues such as systemic racism, white privilege, gender identity, marriage, abortion, and many other hot issues, will always be deeply divisive and destructive of community in government schools. School choice allows dissenters to vote with their feet rather than to fight over the curriculum and books in school choice and books in school libraries. It's like the old cigarette commercial, I'd rather fight than switch. In conclusion, the letter and spirit of the First Amendment deeply values freedom of religion, speech, thought, and belief formation. If these values are to survive in our deeply divided, pluralistic nation, parents must be free to choose an appropriate education for their children without having to sacrifice the benefit of public funding of education. School choice, in my opinion, is the civil rights and civil liberties issue of this present age. And one way or another, either in the courts or in the states, we need to get there. And with states increasingly funding school choice scholarships, it gives young families the choice of voting with their feet and moving to states with school choice. Federalism and foot voting are beautiful things and enable lots of choices of how we're governed. Foot voting, by the way, is the most effective form of voting because it immediately gives you the right to become a new citizen of a state with laws and benefits that are best for your family circumstances. And states with school choice laws will attract families with children. So that's what I have today. Thank you, and I look forward to your questions.
Thank you, Professor Duncan. Do we have Professor Wilson available? Oh, great. Okay. Oh, great. So Erica Wilson is a professor of law. She is the Wade Edwards Distinguished Scholar and Thomas Willis Lambeth Distinguished Chair in Public Policy at the University of North Carolina School of Law. Her expertise includes civil litigation, civil rights, clinical legal education, critical race theory, education law, and public policy. Professor Wilson's scholarship focuses on issues related to education law and policy and the intersection between race and the law. Her scholarship has appeared or will appear in the Harvard Law Review, Yale Law Journal Forum, Columbia Law Review, Cornell Law Review, and the UCLA Law Review, among others. Professor Wilson's work was selected for presentation at the Harvard, Yale, Stanford Junior Faculty Forum in 2017 and again in 2022. She was awarded the James H. Chadbourne Award for Excellence in Scholarship from the UNC School of Law. In 2020, she also founded the Critical Race Lawyering Clinic, a clinic that teaches law students how to bridge the gap between critical race theory and praxis. She is an avid USC football fan and a Los Angeles Lakers fan, hopefully a LeBron James fan for us here in Cleveland. All right. Professor Wilson, her talk will consider the attacks on the so-called critical race theory in the context of the debate on localism in education. When local school boards determine curriculum, allowing local communities to chart their own course, she considers whether that perpetuates racial inequality and anti-democratic preferences. Professor Wilson.
Hi everyone, can everyone hear me? Okay, good. Well, thank you for having me. I'm very sorry that I couldn't be there in person today, but I am looking forward to a really engaging conversation. Since I can't be there in person, I'm actually going to share my screen and show some slides because I know maybe you don't want to just stare at me, so bear with me for 1 second. All right. So hopefully everyone can see the slides. It's hard not being there. Thumbs up if you can see the slides. All right, good deal. All right. So the subject of my remarks and paper are about the so-called critical race theory bans and considering them in the context of education localism. And so this actually dovetails nicely with what Professor Duncan was talking about in terms of school choice and the ability to vote with one's feet. Our system of education localism has actually created a patchwork system within states of so-called anti-CRT bans, and I argue it has some effects on how education can be used to enhance our democracy. So that's what I'm going to talk about today. I'm going to spend the first third of my time giving some context for this principle of education localism. Then I will situate some of the CRT actions that are happening in my home state of North Carolina within the context of education localism. And then I'll conclude by talking about the implications for democracy of this patchwork of anti-CRT actions or pro-CRT actions as well for education's ability to play a enhancing role to our democracy. So I'll start by talking about education localism. And the first thing that's really important to note here is what localism is. And so I use the term localism to mean an ideology that favors decentralized, independent local government structures over more centralized government structures. One of the central tenets of localism is that the provision of government services should be controlled locally, with the interests of local residents as the primary exclusive focus of local decision makers. In the context of public education, as Professor Duncan alluded to, public education has the potential to restructure the relationship between parents and children, to introduce new ideas and values, some of which may conflict with parental ideas and values. So one of the central tenets of localism as far as education is concerned is that vesting the provision of education in the lowest level of local government, which usually turns out to be a local school district, puts education decision-making ideas and policies closer to the family level, to the extent that local parents have the ability to influence education policy, some of which we see with the debates about CRT and the curriculum in public schools. And so in the context of education, although all 50 states contain an education clause that mandates the creation of a public education system of schooling, usually through the 12th grade, most states delegate that responsibility down to the lowest level of local government, which is the school district. And they empower school boards that govern school districts to make various education policies. And the level of locality varies, with some districts being municipally based, some being county based, and others even being regionally based. And so I put up this picture for you to give some context to what I'm going to say after this, is that there are approximately 16,800 local school districts. The blue lines on the map represent every school district in the United States of America. You can see some geographical differences. Within the Northeast and the Midwest, there being many more lines because there are more municipally based school districts in those areas. In the South and West, there are fewer lines, mainly because they are more likely to have county-based school districts and in some instances regionally based school districts. To the extent that some of the nitty-gritty decisions about education policy actually get made at the local district level, the local school board level, this has important implications in the public school setting for what is actually being taught on a curricular level. And we'll see that with the actions that various localities have taken with respect to so-called critical race theory bans. And so the practical import, as I alluded to, is that these local districts bear great responsibility for the day-to-day education that students receive, including school assignment and curricular decisions. I've excerpted an example of North Carolina's Constitution, which sets up a state board of education, which then empowers the state board of education to make any rules and regulations needed. And usually that ends up happening, being delegated down to local districts here in North Carolina at least. Critically, the justification for the system of education localism is nicely set out by the Supreme Court in Milliken versus Bradley, and also in several other Supreme Court cases, where the court has said that local control over the operations of schools is critical. It gives the ability to for citizens to participate in the decision-making process, permits the structuring of school programs to fit local needs, and encourages experimentation, innovation, and a healthy competition for educational excellence, meaning that when we have local school systems that are structured differently, citizens can vote with their feet. There can be an interlocal competition between localities for students based on what it is their district does, what they offer or do not offer that may attract parents. Now, there are usually state standards. Every state has standards and there's some standardization, but what we find is that there is local district variety that can and does influence parental decisions about where they will or will not send their children to school. And so the really important justifications to tease out of this is citizen participation, education, decision-making process, the interlocal competition I talked about, and critically for purposes of thinking about the CRT actions is this idea that you can accommodate our national pluralism and diversity in educational preferences, that people, parents have differences in what they want their children taught or not taught, and that the system of localism, to the extent it allows parents to vote with their feet, is the best way for a system of public schools to accommodate this pluralism. There's also the idea that there's greater accountability. If you are unhappy with what's happening in your children's schools, as we've seen again with the CRT debate, parents can go to their local school board meeting, express their preference and are more likely to have their preferences met. But there are some really important critiques of localism that I think I argue come into play when we think about the CRT actions, both the bans and the positive decisions to incorporate some forms of CRT into curriculum. And I should pause by saying that I'm calling it CRT bans or positive affirmations, but in reality, it's not really, or technically, most K-12 schools are not teaching critical race theory, but this is the label that's been placed on decisions about how we will talk about race and inequality in school curriculum. But the critiques of education localism suggest that it permits inequality between school districts, right? One thing that I haven't talked about, a key principle of localism articulated by the Supreme Court in the Rodriguez decision is that schools can be funded locally based on the tax dollars that are in a particular local district, which creates serious funding disparities. It can create disparities in the quality of teachers, etc. So the idea that we're going to vest local control allows some kinds of disparities and inequality to persist. Most important for what I'm going to say today is that I think there's an argument that it also breeds myopic understanding of community and belonging. If people can sort themselves in communities that suit only their preferences, schools that only suit their preferences, it can in some ways undermine the purposes of public education in terms of melding a diverse group of persons together and making them citizens with empathy and understanding. To that point, it also can fail to situate our students to live in our racially diverse and pluralistic country, which is becoming increasingly important as the country becomes increasingly more diverse, both along the lines of race, class, religion, ethnicity, etc. And so, in a nutshell, one of the main critiques of localism is that given the ethnic and economic divisions between localities, characteristics of many metropolitan areas, there is the danger that education localism can turn into local particularism and result in the propagation of parochial local values inconsistent with the broader goal of education for life in a diverse and multicultural society. And so I want to use North Carolina as an example of both the pros and cons of education localism, specifically using local anti or pro CRT actions as an example. So in North Carolina, the North Carolina State Legislature attempted to pass HB 324, which was a bill that purported to ban the teaching of critical race theory in school And so you can see I excerpted a small portion of the proposed bill that many of the things that public school units shall not promote are things that came from the Trump executive order. Can't promote that one race or sex is inherently superior. An individual by virtue of his race or sex is inherently racist, sexist, or oppressive, etc. What happened in North Carolina is that HB 324 got through the legislature, but was vetoed by a Democratic governor. So HB 324 did not pass. But what we saw happen after HB 324 didn't pass, even though the state bears responsibility for education, I mentioned earlier, our system of localism means that it's some of the practical education policy decisions are actually made by individual boards of education who have control over local districts. And so what we saw happen was the North Carolina State Board of Education approved new social studies standards. And the new social studies standards set forth some objectives about how various principles in social studies should be taught. The policies were aimed at having a more inclusive version of social studies, and it meant a lot of consternation in various local communities. And so the combination of the state bill on banning CRT not making it through, along with the State Board of Education standards, led to many local boards creating their own either resolutions or policies that essentially sought to do the same thing that HB 324 did at the local level. So subverting the state bill being vetoed and instead enacting these local resolutions or school board policies that had the same effect. So what we saw in North Carolina was that there were 19 total actions related to critical race theory. 15 were anti-CRT, 4 were pro, 7 were actual school board policies, some were resolutions, 6 were actually resolutions, 2 were superintendent statements, and then the last 4, the 4 in the remaining boxes were purported to be pro-CRT actions, and so we saw 1 Black Lives Matter week of action, 1 pro-school board CRT school board resolution, required equity training, and 1 teacher equity grant application program. So I think it was fair to say the anti-CRT actions had a more direct effect on the curriculum than the so-called pro-CRT actions that were taken at the local level. But here's an example of one of the resolutions that was passed in one of the counties, and you can see that it's almost verbatim the same as the House bill that did not pass. The important part for my analysis here is understanding the geography of how this happened, where these things happened. So the 19 actions are depicted in the colored county boxes. The yellow is where we had anti-CRT actions, and the orange is where we had pro-CRT actions. And you can see there are these clusters of pro and anti-CRT actions, creating, as I mentioned earlier, this patchwork of different localities doing different things in terms of how they were going to handle their curriculum. And so this definitely tracked race. I couldn't put all of the county demographics on this very limited slide, but the first 3 counties depicted on the slide were anti-CRT actions were taken, and most of these localities were overwhelmingly white with a smaller number of students of color. The one pro-CRT action that was taken in Durham County was more of a racial plurality with less than 50% white and over 50% students of color. And so a summary of the demographic information shows that in the 15 counties that took anti-CRT actions, the student bodies in each of the counties was at least 65% white, and the pro-CRT actions in those counties, the student bodies were at least 40% students of color. There were also political divisions in 14 of the 15 counties that took anti-CRT actions. Trump garnered more than 50% or more of the electorate vote. On the 4 counties that took pro-CRT action, Biden garnered 50% or more of the electorate vote. And so this, I argue, has really important implications for this concept of education localism, and more importantly, implications for our democracy. One thing that often gets lost in this conversation about education and curriculum and what will or will not be taught in schools was that the system of free public schools developed mainly for the purposes of supporting American democracy, inculcating students, future citizens, with certain civic virtues and values. The founders believed that a system of publicly operated schools would be the best vehicle for melding students from a wide swath of backgrounds, inculcating a shared civic virtue, and turning young people into competent and virtuous citizens. And so what we have now is a burgeoning multiracial democracy, I argue. Our previous conceptions of democracy at the time that our free system of public education was developed was not a true multiracial democracy, because we had express laws prohibiting non-whites from fully participating in the democracy and being true citizens. So we are now attempting to have a true pluralistic, multiracial democracy. And for that reason, education is going to play a vital role in whether or not we can successfully do that. And so in a democracy, state-sponsored education is supposed to create citizens by inculcating shared community and preparing students for the responsibility of citizenship. And so I suggest that the assault on CRT in some ways is a thinly veiled threat against those deemed by the majority to be outside the sphere of citizenship in terms of how we see our history, what our our children are being taught or not taught. The state, however, I think has an obligation to teach students respect for opposing points of view, to provide them with the intellectual skills necessary to evaluate ways of life that are different from their parents. And so, sorry about that, my Siri watch. But when we look at the CRT actions, it raises a question then, if that's the purpose of education in our democracy, whether or not these CRT actions are actually a form of healthy education localism at work. One could argue that education localism is a way for maximizing, it's worked in this sense. It's maximized the democracy-enhancing functions of public education by allowing parents to have a voice and to make a difference at the local level in terms of the curricular changes. The communities disagreed with the state standards and participated in their local process to get clarifications that suited their communities. These smaller units of government allowed for their preferences to be accommodated and given the reality of interlocal competition and resident sorting, maybe it's not a bad thing that we have this patchwork of anti and pro CRT actions. The converse argument to that is that it may also be an example of what I call destructive localism at work. Destructive localism, I argue, occurs when groups enjoy local autonomy, but they do so in ways that results in them forming racially and economically homogenous community, taking advantage of the benefits of being connected to a larger network of municipalities, and inflicting tangible and or intangible harms on neighboring localities. So what's the harm here that I argue? I argue that the harm, the CRT bans arguably effectuate new and equally pernicious forms of destructive localism through the propagation of parochial local values inconsistent with the broader goal of education for life in a diverse and multicultural society. Given the varied lifestyles and cultural preferences The counter argument goes, CRT actions are a healthy sign of American freedom and choice, not destructive or exclusionary, because it demonstrates the ability of America's varied communities to find solutions that work best for them. I actually conclude by suggesting the answer is somewhere in the middle, right? Some local variations can be a positive and further the positive benefits of education localism that benefit the American democracy. However, some of the local actions and practice, I didn't have enough time to talk about it, have turned out to be effectively memory laws, which enshrine state-approved interpretation of crucial historical events and promote certain narratives about the past, and will certainly shape future citizens' views about the future. I conclude by suggesting that we have to walk a careful balance between the local autonomy and destructive localism being used to inculcate students with values that threaten our burgeoning multiracial democracy. So I am right at time, so I will stop there, and I look forward to hearing any questions folks have.
Thank you, Professor Wilson. Of course, we'll have a question and answer session after all the speakers are finished. Our next speaker is Emily Spivak, who is a senior associate at Squire Patton Boggs, where her practice focuses on issues facing employers in public school districts. Emily's practice includes advising school clients in student discipline matters, special education disputes, contract and policy drafting, and employment questions. She regularly defends districts before the Ohio Civil Rights Commission and the U.S. Department of Education's Office for Civil Rights. She also has extensive experience in public records and public meetings questions, both under Ohio's Sunshine Laws and the Federal Freedom of Information Act. Most important, Emily is a 13 graduate of Case Western Reserve School of Law, where her favorite class, I am certain, was Professor Jaffe and Professor Carney's education law class. She also had the unenviable experience of working with me at Squire Patton Boggs for a short period of time. Emily will describe day-to-day First Amendment challenges facing public schools. She'll describe the interplay between student and teacher free speech rights that she's encountered in her practice. Topics may include student publications, presentations, student artwork, social media, school libraries, dress code enforcement, and teacher professional conduct. Emily.
All right, so as Professor Jaffe said, my role today is to talk about some of the practical issues we see day to day in schools. And so I'm going to do a quick overview of some of the applicable law, just so we have a framework to work from. And then mostly I'm going to throw out some stories that we can discuss a little bit later, and I'm sure my fellow panelists will have thoughts on as well. So as I start, much of what I'm going to talk about today has actually been pretty well established law for a long time. And what we're seeing now is an effort to try and redefine it in some ways, and then also try to fit our modern world into old standards and customs. So first, let's talk quickly about the basic parameters of public school students' rights. We have Tinker, the substantial disruption test. That's what we deal with the most. And then, of course, we have the fact that schools can prohibit student speech that promotes illegal drug use, oddly specific, but it does come up. Speech that is lewd, vulgar, or profane and occurs on school property. Key note there. Speech that is considered school-sponsored. So if it's part of a school-sponsored publication, for example, then that can be regulated. I don't know if Professor Scharf is still here, but I was the editor-in-chief of the Shake Right when I was in high school, and that was a designated public forum. So schools can designate certain school speech as outside of the school's review, and when they do, it is not school sponsored. But what is happening in schools as curriculum can be regulated as school sponsored speech. And then the final point is what we just got recently: speech that constitutes a threat aimed at students or staff, severe bullying or harassment, plagiarism or similar offenses. And that's where we get into the question of how far can we reach off campus to address some of those issues. But that's our most recent addition to school regulation of student speech. On the employee side, and I will say it is much more complicated than what I have up here on the slide, but just to give a very quick and general overview, public employers are of course subject to the First Amendment, but there has been some effort not to disadvantage the public employer over private employers. So there is an understanding that when you are speaking as an employee, when you are going about your work as an employee, your employer has some right to control what you're saying and doing. So we'll talk about some examples of how far a public school district can go in regulating employee speech, and how some of what's been happening in recent years fits into this analysis. Okay, I want to highlight quickly some special rules we have in Ohio with regard to public employee speech. So for teachers and other licensed professionals in schools, they are subject to the Licensure Code of Professional Conduct. There may be some arguments that the licensure code might go beyond what the First Amendment would actually permit employers to do, but there are restrictions on employee speech contained in the licensure code. And so you see here, Principle 9 of the licensure code, which was only added in 2019. I think that's how long it took the state of Ohio to realize that social media was a thing. And teachers are out there doing all sorts of things on social media that we'll talk about in a little bit. But this was an effort, a pretty explicit effort, to regulate employee speech, not just on campus, not just in the course and scope of their job, but very broadly. This is intentionally broad enough to encompass personal speech on your personal social media accounts if you are a public school employee in Ohio. And the ramifications of this can be pretty serious because teachers can lose their licenses for violating Principle 9. The range is up to a 5-year suspension of your license. And during that time, of course, you wouldn't be able to teach in a public school. So this applies in Ohio. And then as a result of this, we saw board policies going into effect to try to mirror some of that language. And so we do have language regulating what staff members can say, particularly in relation to their work in the district. And then we have the specific social media policies. And you'll see that the language in these policies hews closely to Principle 9. Again, an explicit effort to reach off-campus, non-employment related employee speech. Yeah, and so there are some First Amendment concerns with that, of course, but as you'll see from some of the examples from an employer perspective, it can come in pretty useful. Other rules that come up in these policies, of course, that staff members may only use district technology resources to access social media when done for school purposes. So that's a bit of a regulation on the teacher's time at school. Don't be on your personal social media at work. There are general school rules for behavior and communication that apply to staff use of social media. And then the disclosure of personally identifiable information about students is, of course, prohibited. I wanted to throw this slide up. This is more attempt to regulate staff members online. This, I think, is a useful discussion point as we move into Q&A later, but attempting to require that staff members at all times be polite, courteous, and respectful online. I'm sure we all have exactly the same definition of what polite, courteous, and respectful means, right? Clearly defined. Not engaging in personal attacks, that's a little bit easier to define. Not harassing another person, that's probably the easiest to fit within our current First Amendment jurisprudence, and not to cause damage, disruption, and that sort of thing in school. So those are the parameters, really, for the examples that I'm going to talk through at this point. So starting with spoken and written expression in schools, and I'll just say, These were some of the examples I have seen in the last few years. There are countless. So looking first at some student speech concerns, we'll contrast two things. The 2016 election was exceptionally difficult for schools. It was difficult, I think, everywhere. But everything that we saw playing out in the national discussion was also playing out in school buildings. And so we did have a group of students. One district comes to mind, although this happened in several of my districts, where a group of white students in a pretty homogenous district went up to their Latino classmates and told them to go back to where they came from. Okay. This was speech that the district addressed and disciplined because they did so under their anti-harassment policy. This was targeting others based on their race, and so we were able to address it, although it was difficult because, of course, the argument was that public figures were out in the world saying and doing the same things with no repercussions. And so there were a lot of conversations about how the school environment is different from being out in the world. Although you don't concede all your First Amendment rights at the schoolhouse gate, you concede some. By contrast, we get to the 2020 election, and students are wearing MAGA hats, Trump gear, promoting, President Trump's reelection, and other students didn't like that, right? They went to the office, they felt that this was, harassing in and of itself, that nobody should be promoting these views, and so on and so forth. There's nothing a school can do about this, right? This is straight political speech. This was protected under Tinker. When we look at material and substantial disruption, we are talking about hundreds of calls to the office. We are talking about news crews on the front lawn. We're talking about students walking out. We're talking about serious threats to safety. We're not talking about 20 or 30 kids saying, I'd rather vote for Biden. That's not a material and substantial disruption. And so we have seen varying versions of these two scenarios play out pretty much constantly over the last 6 years or so. And so districts are consistently having to toggle between these two approaches. On the employee speech side, with similar facts though, we've had different outcomes. So after George Floyd's death, in one of my districts, an instructional aide who happened to be Black posted on her personal Facebook page in support of the Black Lives Matter movement. Nothing inappropriate in the post itself, just expressing her support for the movement. She happened to be Facebook friends with a colleague who was a teacher, and the teacher responded to the post, accusing the aide of being anti-police and expressing support for police officers. Had it ended there, I likely would not be talking to you about this. But what ensued was an 18-hour back and forth between the teacher and members of the community who spoke up in favor of the aide and support of not just the Black Lives Matter movement, but more importantly, the aide as a human being. And the teacher spent 18 hours telling parents and community members that they were stupid, that they were idiots, that they didn't know how to deal with their children, that the aide was just an aide, not a teacher, and therefore did not matter, that they shouldn't be supporting her. I don't know about any of you, I could not spend 18 straight hours on anything, let alone a Facebook conversation, but that is how this woman chose to spend her time. And I think there is a valid question as to whether the district could have imposed discipline under the First Amendment. But at the end of the day, this teacher could not return to the classroom in that district. She's no longer working. This was a 25-year teacher who recognized that she needed to move on. She had lost all credibility in that district. Now, push comes to shove, like I said, could I have defended a termination on that basis? I don't know. Perhaps my colleagues have some thoughts on that. But this was not somebody who could remain in that position and have credibility at the head of a classroom. So part of what we look at in the practical realm here is this is a teacher who would have been instructing a diverse group of students. And the second a student of color walked into her classroom and got a bad grade, she would be questioned, having had this conversation very publicly online. And so there are considerations in addition to the question of, under the First Amendment, hypothetically, can she say this? Then we get into the practical reality of, still, what does that mean for your job? Another scenario was following the insurrection at the Capitol. We had a bus driver remark to her aide that she wished she had been there so she could have taken out some Biden supporters. Not really a direct threat, right? The event had ended. Taken out, I suppose, could be interpreted in different ways. But the aide, being a Biden supporter, wasn't thrilled with this comment. And the district was diverse enough that there were certainly parent Biden supporters who would be waiting at bus stops with their children. And so the aide reported this comment to the administration, and the driver, believe, was issued a reprimand, because at that point you are promoting violence in the school setting. Now again, I think it is up for debate if that driver had really challenged it, whether that would have held. But at the end of the day, sometimes schools just, they have to at least be on record as saying we don't want our employees making these kinds of statements. Okay. More recent example, dealt with a Black administrator who had shared a video on her personal Facebook page. It was actually quite well done. It was a song about being a Black woman in the workplace and what it's like to be in that position. And really what it came down to was some of her white colleagues, it must have hit a little close to home. Let's just be honest. That's probably what happened, right? But they were sad. They thought they were her friends, and they took this as a personal attack. So the principal and the superintendent met with her about this and suggested that she take it down, which ultimately she did, I'm a little sorry to say. That is not a scenario where I think the district had any First Amendment grounds to stand on. The song was not inappropriate in any way. There was not inappropriate language, there wasn't threatening language, there wasn't anything questionable in it. It was clearly on her personal Facebook page, and it didn't cause any kind of disruption in school. But ultimately she did take the post down. By contrast, we had last year a school where the masking policy was sort of going in and out. And parents, there was a group of parents that was extremely upset anytime the masking policy was in. I'll talk in a minute about the argument that masks themselves raised First Amendment issues, but we litigated that whole mess. And in this case, this poor elementary school principal, she would retweet, school's closed, right? She would retweet the superintendent's announcements about the district. She would retweet her building's announcements, about what was going on in the school. And this group of parents just went after her on her personal Twitter page. So she blocked them, her page. And they came back threatening a lawsuit, alleging that simply because she was a public employee, her page became a public forum. Interesting concept, but if you take that to its logical extreme, it would never work. You can't possibly assume that every time a public employee speaks in a private capacity, they are somehow creating a public forum just by virtue of their public employment. That's what we argued, and we did win on that one, which I was pleased to see. But it does get a little dicey when she's retweeting everything from the public account as well. So I am constantly emphasizing to public employees that they should not be identifying their public employer or associating their employment with their private social media pages, because it just creates a lot of confusion around issues like this. Okay. So turning to symbolic speech in schools, we have some frequent flyer symbols, which I'm sure will come as no surprise. The Confederate flag, I don't know if it's a resurgence or if it has been this popular consistently, but in the last few years, I get a million Confederate flag questions. And courts have basically said, in school districts where there is a history of racial unrest, the district can regulate the Confederate flag. It can say, you know, you're not allowed to wear Confederate flag gear. I have one district that called a few weeks ago because some kid was flying a giant Confederate flag off the back of their car in the school parking lot. That caused some consternation. When confronted, by the way, that kid claimed they had no idea what the Confederate flag meant, took it down. I don't know. But in districts where there's no history of racial tension, racial unrest, racial violence, there's not much the district can do when it comes to the Confederate flag. And we've seen the same kinds of analysis on Black Lives Matter gear, on MAGA gear, on LGBTQ pride gear, on straight pride gear, thin blue line attire we saw come up in the last few years. All of these symbols that send messages about one's, you know, political, social beliefs, there's very little a district is going to be able to do, at least in the student context, when there's been no history of unrest. There is some question whether schools could regulate it a bit more in the context of an employee, right? We have more control over employees and their dress code as it is, but it's very important at that point to be completely content neutral. So we've seen where employers have dress codes that say you can't wear any political messages, you can't wear anything with words on it, but they don't enforce it until somebody walks in with a Black Lives Matter shirt or a thin blue line shirt, right? You're not gonna be able to enforce it at that point. So while we have more leeway with employees than we do with students, what a lot of districts found is that they hadn't been enforcing these policies all along, and they had basically lost the option to do so. I do want to touch on masks, although we have, I hope, mostly moved past this issue. It seemed for a while there that I was spending all of my time briefing on the First Amendment implications of requiring people to wear masks. And so the threshold question there was, does a masking policy constitute compelled expression? And courts across the country essentially concluded no. This case I have up there out of Maryland, I thought put it most succinctly, which was to say wearing a mask right now, and this was in 2020, conveys nothing other than you don't want to get COVID, or you are complying with a masking requirement, not to, So it wasn't expressing any other kind of view. There may be an argument now sometimes that wearing a mask is expressing more of a view, but I think the courts have been clear that that was not compelled expression. And then courts went further to say even if it was compelled expression, did the government have a compelling interest in implementing that? The answer was yes. And so the roughly 150 parent letters I had to respond to complaining that districts were violating their children's First Amendment rights all went something like this. Now we get to student artwork, and these examples are fun. This does get a little bit trickier, right? Because when you have students doing work in a classroom setting, right, we've talked about Hazelwood will apply where it could be read as government speech. But when you tell a student to do a project, write a paper, pick a book, do an art project, as long as the student does their project within the confines of the assignment, the school doesn't have much leeway in regulating what that project looks like. So in this case, the school had an art show, and I suppose it was important that the little kids could attend the high school art show. And one student's art, which was quite good, depicted a woman's torso. And it was nude, but all of the, I'll say, important parts were covered. Right? Her chest was covered, the pelvic area was covered in flowers, so not even something particularly outrageous. And then the student had also painted a photo of a uterus in shackles and had put on the ball and chain property of the US government. And there were a couple of board members who really did not appreciate this artwork and asked the superintendent to pull the artwork out of the show. On the theory, by the way, that this art was obscene. All right. So we'll just review quickly the definition of obscenity, which is work that appeals to the prurient interest, depicts sexual conduct in a patently offensive way, and lacks serious literary, artistic, political, or scientific value. And I will say we apply a slightly different level of obscenity test when we're talking about exposing young children to things, but even with young children in this audience, there wasn't anything even borderline obscene about these paintings, okay? And given that there wasn't obscenity, that the level of nudity was probably mirrored in the European history textbooks that the school had, there was nothing that the district could do about this. When it came to the painting of the uterus, had the district tried to pull that down, I think they would have been subject to a viewpoint discrimination claim on that point, because that was quite clearly political speech. Same district. Two students worked together to paint a mural on the wall in the library. The mural depicted fantastical versions of the students, so not quite human looking. One of them had really pointy ears, like it looked almost alien. They clearly weren't supposed to be self-portraits. One student happened to be much taller than the other. This was middle school, so no surprise there. One was tall, one was short. They were holding hands. In the background of the mural, they had painted a lesbian pride flag. This was, by the way, 5-6 years ago, so the mural had been on the wall for a while. But all of a sudden, a parent got it in their heads that this was child pornography, this was promoting pedophilia, and it needed to come down. And the board had a lot of public conversations about this, and the fact that that was why they wanted the mural to come down. And we had a lot of not public conversations about how you can't just pick one mural with a lesbian pride flag and say it has to come down, and also how this isn't pedophilia or child pornography, again referencing definitions that we have in the law. And so ultimately, after a year of discussing this very publicly, they said, well, we want to do it anyway. I say, well, it's the surest way to get hit with a viewpoint discrimination lawsuit, because you've just been out there for a year talking about the fact you want to do this because you think these students are lesbians. So ultimately what the school has decided to do is paint over every mural in the building. Just do away with all of the student art so that we don't have to talk about this one piece of student art. So moving from there, just briefly to touch on school libraries, because this is another issue that we've seen a lot about in recent years. Boards have almost total control over their curricular materials. The Ohio statute is up there. The key decisions at the federal level are there as well. Interestingly, you'll see the same two decisions on the next slide about school libraries. So both the Pico case and the Minarsini case found that boards could strictly regulate their curricular materials. Both of them also found that boards couldn't do much with library books once the book was in the library. And so we have seen efforts across the country recently to ban certain library books. They have not been particularly successful, at least in our Ohio districts, because of these cases. And with that, I will turn it over.
Thank you, Emily. Our final speaker for the morning session is Will Creeley. Will joined the Foundation for Individual Rights and Expression, acronymed FIRE, in 2006, where he currently serves as legal director. As legal director, Will coordinates FIRE's legal advocacy and oversees FIRE's litigation, legislative and policy reform, and targeted advocacy departments. He's appeared on national television and radio on FIRE's behalf and has spoken to thousands of students, faculty, administrators, and attorneys about First Amendment rights at events across the country. He is a co-author of First Things First, a modern course book on free speech fundamentals. His writing has been published in the New York Times, the Wall Street Journal, the Washington Post, the Chronicle of Higher Education, and others. He has co-edited FIRE's Guide to Due Process and Campus Justice and Guide to Free Speech on Campus, and has authored amicus briefs submitted to courts nationwide, including the Supreme Court. He serves as co-chair of the Education Subcommittee of the American Bar Association's section on administrative law and regulatory practice. He's a 2006 graduate of NYU School of Law, where he served as an associate executive editor for the NYU Law Review, a proud native of the shores of Lake Erie in Buffalo, New York. Will now lives in New Jersey with his wife and 2 children. And he will speak on the Mahanoy Area School District VBL case decided in 2021 regarding a disgruntled cheerleader's misguided teen spirit and her social media posts, and suggests that presented a missed opportunity.
Thank you. Thanks, folks. It's a pleasure to be here. Thank you very much to Kennedy. Thank you very much to all the Law Review staff. Thank you to Professor Anton. And thank you to Eric Seiler for the work. And it's an honor to be here with my distinguished co-panelists. One of the problems of going last in the morning lineup, batting cleanup here, is that there's so much that's been said that I kind of want to ditch the 20 minutes I had planned just to talk, particularly about Emily's presentation, because as a First Amendment attorney working for a free speech advocacy group, there's a lot to chew on there, Emily. I'm thinking about, just start, if I may, briefly, what is FIRE? We're a nonpartisan nonprofit. We've been around since 1999. For much of our existence, until this past June, we dealt exclusively with higher ed rights, student and faculty rights. I actually had the pleasure of working there with Law Review alum and Case Western alum Caitlin Patton, who is here today, and is now clerking for Judge Calabrese in the Northern District. And one thing about those library points that Emily just mentioned, PICO is undoubtedly weak, and this is not what I want to talk about, but I would very happily go for 20 minutes on it. And we are actively looking for students to strengthen PICO in the various circuits. So if you have younger siblings who are in high school who find themselves subjected to a partisan book ban, please direct them to thefire.org. We will leave no stone unturned in our search for plaintiffs. And as Caitlin knows, we will even send attorneys with 3 days' notice to Nampa, Idaho, to talk to residents and local booksellers. If the school board there had followed a policy, maybe Caitlin wouldn't have got to explore the Boise area, but they didn't, so there we were. So as I say, we've been around since 1999. We're proudly nonpartisan. My line when I meet folks is that I can give you 5 cases I've worked on that'll leave you thinking I'm a freedom fighter because you'll agree with the underlying politics. I can also give you 5 cases I've worked on that will make you think I'm the devil incarnate and everything that's wrong with America. So it's a nice way to meet folks at parties. I urge you to check out our website. I won't go into much more detail. Again, part of the other problem with going last is that some of your thunder has been stolen, so I won't go into too much of the framework that Emily very helpfully and much more concisely summarized than I will, but I will give you the pictures. There's John and Mary Beth Tinker with their iconic armbands from Tinker v. Des Moines. The basic rule here, absent a forecast of substantial disruption of or material interference with school activities, the speech is protected. There's an important corollary here, which I ask everybody to keep their eyes on, because I think it is an emerging area of jurisprudence, particularly post-Mahanoy. The invasion of the rights of others prong in Tinker, which is mitigated to some extent by federal anti-discrimination law, or at least dictated by federal anti-discrimination laws like Title VI and Title IX. But watch that space, because we have seen school districts advance the argument that while this speech may be protected off campus post-Mahanoy, and while this speech may be of political interest, it constitutes a violation, or an invasion of the rights of others. What those rights are is somewhat hazy. So we'll get back to that in a little bit. There's Matthew Fraser, named plaintiff in Bethel School District number 403B Fraser. Folks may remember this when I'm speaking to high school audiences. This is the highlight of the speech where I talk about some of Fraser's speech that he gave to his classmates, nominating a fellow student for a student government post. I won't read everything to you. Just let's say it's laced with sexual innuendo, and the court in 1986 did not find it funny. They said that, and one great thing is Professor Wilson's talk noted you get to use the verb inculcate a lot when you're talking about K-12 speech. The role of public education, the court opined, was to inculcate the habits and manners of civility as values in themselves conducive to happiness and as indispensable to the practice of self-government in the community and the nation. I'm the father of an 8-year-old and a 5-year-old. I'm often telling my children what I'm trying to do is inculcate the habits of civility as happiness in and of itself when you're quiet. So it doesn't always work. Moving on, Hazelwood School District v. Kohlmeyer, as Emily mentioned, this is the case involving the principal. There he is, Robert Eugene Reynolds, censoring student newspaper, The Spectator, by clipping out prior to publication articles on divorce and teen pregnancy at the school. I had the pleasure some years ago of attending a panel where for the first time the student editor pictured here, whose name I'm forgetting, and the principal, Kohlmeyer, of course, and the principal saw each other for the first time since graduation. And the enmity was palpable. They still did not like each other. It was by far the feistiest panel. It was fascinating to me to watch. But yeah, so the basic rule is reasonably related to legitimate pedagogical concerns and school-sponsored expressive activities. So we'll skip this slide basically, but this has been pushed back on a lot by the Student Press Law Center, an excellent nonprofit that I'm proud to work with often. We've passed New Voices legislation in a number of states, pushing back on the reliance on Hazelwood and overruling Hazelwood in both the K-12 and higher ed context. Morse v. Frederick, Bong Hits for Jesus, my personal favorite of the school cases for now. This is the students in Anchorage, Alaska, who unfurled the banner, as you see here, Bong Hits for Jesus. Nowhere in the court's opinion did you read the word joke. It happened off campus, but as Emily said, weirdly specific rule, schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as encouraging illegal drug use. Now, as noted, I believe in the concurrence, I want to say by Justice Alito, had this been a political statement, perhaps it would be different, right? The ambiguity of the joke, if I may presume it was a joke, I think it was a joke, although there's an interesting argument about religious speech there if you want it. Had you construed it as a joke, or as a pro-marijuana legalization banner, it might have been different. So K-12 online speech cases will be entering the jurisprudential desert here, right? So get yourself ready, right? This has been a long 15 years. Actually, let me first start by saying, when I joined FIRE in 2006, we were doing exclusively higher ed work. And when I talked to audiences of attorneys and educators, I would have to identify Facebook in a way that now seems long distant and anachronistic. I would have to say popular social network site, Facebook.com. And some people say, oh, my kids. Yeah, no, I've got a cousin or a nephew who's on there. Yeah. And that seems like a long way away. One point that Fire President, CEO, then legal director, and I made early on is that the difficulty presented by Facebook for administrators is real. You have been afforded a new kind of visibility into conversations that previously would have vanished into the ether. You can now hear the locker room conversation. You can now hear the conversation about a teacher or an administrator that students would have crossing the quad. What do you do with this powerful new visibility, right, with student speech? Do you render unto students in their private moments what is theirs, or do you monitor and attack? And we urged the latter, but the temptation was too great. And that was at the higher ed level. In K-12, it's far different. I could have picked any number of these cases. I picked Doniger v. Niehoff from the Second Circuit because the facts here remind me of a kind of classic PG-13 Disney movie. You know, let's get the band together and have a concert, but those dastardly school administrators are going to shut us down. It's a little bit like Footloose in that way. We had a student who was a member of the student council, and she wanted to criticize, or she had criticized the administration for rescheduling Jam Fest, which is the annual student concert. And there was some question as to whether or not they could perform Jam Fest in an alternate location or an alternate date. She organized a letter writing petition and galvanized student and some parent support. The students and parents emailed the district. The secretaries who were receiving the emails apparently missed a few meetings. They had so many emails, their inboxes overflowing. My heart breaks for them, of course. And that was enough of the disruption. She called them douchebags too, as I remember. The volume of calls and emails received by 2 school officials in response to the student's blog post is sufficient evidence of a foreseeable risk of substantial disruption. So think about the civic lesson here, going back to Bethel, inculcating the habits of civility. And as Professor Wilson mentioned, right, the idea that we are teaching students for how to succeed in life in our pluralistic democracy. So here we had a student who's essentially punished for running a good advocacy campaign, right? For being civically engaged, an elected student official, and her punishment was that she could not run again. So I ask you what kind of lesson that is. Other circuits followed suit, applying Tinker to off-campus online speech. Again, I won't go through chapter and verse of these, but that was emerging as the general rule, that schools could apply Tinker to reach out past the schoolhouse gates into the social media presence of their students. When students speak online or off campus, they must do so at their own risk. One last case I'll note that's particularly interesting, Bell v. Itawamba County School Board, involving a student who is an aspiring rapper and posted on his YouTube page a rap criticizing 2 phys ed teachers who had been allegedly sexually harassing female students. Again, kind of classic whistleblower activity that we might think of as essential to democratic functioning. The post and the verses included, I think of the recent legislation passed in California about the use of rap lyrics as evidence. The posts were kind of classic rap posts with hyperbolic references to violence, etc. But the Eighth Circuit entertained the fact that they could have constituted a true threat against the named phys ed teachers. The dissent at the panel level said, what are we doing here? We're punishing off-campus speech for the impact it had on campus, but the impact was really just embarrassing the phys ed teachers. Goes up to, there's a fairly well-publicized petition for cert, had rappers like T.I. and Killer Mike signing on in support, kind of again beginning to galvanize this burgeoning movement to restrict the use of lyrics as evidence in criminal cases. So it's an interesting cultural moment, but the petition was denied. So that's where we have it when we get to the Cocoa Hut, and there is the Cocoa Hut. And one day I'm going to go to the Cocoa Hut, and I'll post it on my Twitter feed, so stay tuned. But that is the Cocoa Hut. And really, I'm talking about this mostly because I just wanted a piece of scholarship out there that said what happens at the Cocoa Hut does not stay at the Cocoa Hut. And this is where BL and her friend, there we go, go and post their fuck school, fuck cheer, fuck everything post, right? On a Saturday night at the Cocoa Hut. And one thing about Mahanoy that was interesting, actually came up in the dinner last night, that when Fire submitted our amicus brief to the Third Circuit in support of the ACLU of PA's position and BL on her First Amendment case, really the grounds on which we were fighting at that point was whether or not you had a right to be a cheerleader, right? Whether that constituted sufficient punishment for First Amendment rights to attach, or whether by joining an extracurricular group like a cheerleading group, she had waived some of those rights, right? You don't have a right to tell your football coach if you're the quarterback to go to hell, right? He can make you run laps. Whether or not he can kick you out of school is another question. Actually, that raises, just as a quick aside, that raises interesting questions in the higher ed sphere, where Fire has argued that relying on First Amendment protected speech to deny a student without due process an academic scholarship or revoke an academic scholarship when that academic scholarship is the but-for of how they go to this public school might implicate important First Amendment interests. And that's an interesting case we're still waiting on in the Second Circuit involving a Radwan, Noriana Radwan, who's a soccer player for UConn, who in victory gave an ESPN camera the finger and lost her academic scholarship as a result. So kind of stay tuned for that one. That one's been out for a while. We should get that soon. Anyway, putting that aside, that's not the grounds that the Third Circuit decided Mahanoy on. The Third Circuit instead decided to flip over the table and say, we're tired of this wandering in the desert. We're tired of the mishmash of circuit approaches. And we don't think that the school officials in K-12 should be able to reach the long arm out into social media posts. And they said, instead, to enjoy the free speech rights to which they're entitled, students must be able to determine when they're subject to school authority and when not. And finding that the interests that schools serve, acting in local parentes, educating and inculcating values, etc., those cut off when students walk off campus. And they proposed a fairly bright line. On campus, subject to school control. Off campus, you're on your own. The Third Circuit importantly did reserve the question, this gets lost often, as to off-campus student speech that threatens violence or harasses others. And I think that was an important reservation that got lost somewhat in the briefing. The district appealed, and we went to the High Court. Some of the briefs for the High Court were particularly noteworthy. The American Civil Liberties and Justice Association, the ACLJ, did I get it? American Center for Liberty and Justice filed, thank you very much. I can never, there are too many acronyms, I can never remember that one. They filed an interesting brief arguing that, in support of neither party, arguing that, frankly, if anybody should take an action, it's the parents, right? It's not the school's responsibility. It's not the student's right, per se. The party that is empowered and best equipped to take action would be the parents. That was an interesting argument from a conservative advocacy group. The school boards argued in favor of their power, that to be able to run the school, they have to be able to monitor social media in this way. First Amendment advocates like FIRE, the National Coalition Against Censorship, and the Comic Book Legal Defense Fund, which joined our brief, argued otherwise. We argued that the Third Circuit got it right, that there is stability and clarity in the precise on-off distinction. And we compiled a long list of examples of students getting punished. And some of Emily's examples would have been very helpful. I was writing this brief of students getting punished for off-campus speech, quoting Mean Girls, posting a picture. One student posted a picture with her brother, both of them wearing, I think it's called shadés, Middle Eastern face coverings, with their legally owned firearms, and saying, we're off to exercise our Second Amendment rights, and this is me exercising my First Amendment right. That's fully off-campus. Licensed gun owners had students taking pictures of lawfully owned firearms and saying, if you know where the zombie apocalypse, when the zombie apocalypse hits, you know where to find me. Picture of a toy gun, posts of cheerleaders next to Trump signs, posts of students next to Black Lives Matter signs, basically the world in a nutshell, everything Emily described. So we found all this wide variety of speech that should be protected off campus, but nevertheless resulted in punishment. Even speech, frankly, that's just kind of low level and jokey. Not only the Mean Girls quote, but a senior at a high school in Massachusetts who said, "There's a snow day, hashtag fuck off, hashtag seniors," right? And that was that. And he was punished for it. So again, what we argued is that the educational impact, the pedagogical takeaway here for students is that you live in a panopticon. You can never escape the state. It will always watch you. There is no offline. When you go home, whatever you write will be monitored. Your friends will rat you out. You better keep your mouth shut, especially if you're talking about anything controversial. It's an interesting case that goes up to the High Court. It could very easily have been the straight pride flag, right? Or it could have been thin blue line pictures. It could have been, I hate Black Lives Matter. It could have been, I love Black Lives Matter, depending on your district. But this one went up. So we also pointed out that what happens here, and again, given the fact that we did higher ed advocacy for almost 21, 22 years now at FIRE, we pointed out all the analogs at college because high schoolers often become college students, and when they do, they continue to post offline, and they continue to be punished for those posts, right? We had a student who was in a messy breakup, and his girlfriend wrote a pretty incomprehensible and grammatically flawed letter to him, breaking up with him. So he screenshot the letter, marked it up in red pen, and posted it to Twitter. It went massively viral. And he was suspended as a result of posting that letter under Title IX. So it hits the court, and we won't go too far. I will assume some familiarity with the outcome of Mahanoy. Although, did anybody ever actually see this picture? I'm not sure how many people actually saw the picture. This is the famous post, right? And note that all you've got is someone taking a picture of a picture. Right? This is what made it up. I think it should be on a T-shirt somewhere. It's interesting. So in Justice Breyer's fashion, he didn't give us the bright line rule. In fact, he walked back the Third Circuit's bright line rule. He explicitly rejected it. Said instead what we have is, instead of a rule, we're going to have just a kind of general sense of three features of off-campus speech, right? Off campus, you don't have in loco parentis. We cannot have the panopticon. We cannot teach students that they're under 24-hour surveillance. And this is the interesting one. The school itself can perform an educational function by teaching students that unpopular speech is protected in our pluralistic democracy, called schools the nurseries of democracy. Let's just have a very quick look, and I've screwed up. I left all my time on the cutting room floor, so you'll have to stay tuned for the article. But what I'll be writing about is what Mahanoy means, because we celebrated. You could have heard me. Caitlin will remember from the office. I was very loud and very happy when it came down. I did not think it was going to come down. Since Tinker, every K-12 decision has cut away its student speech rights. This one, again, in somewhat a mushy way, held the line. So I thought, great, this is a victory. All kinds of flowery dicta that I'll be quoting until the end of time. But the rule itself is less certain. But so far, the test is interesting. Here's C1G v. Siegfried, which FIRE participated in as amicus, where this Snapchat got a student suspended. Me and the boys about to exterminate the Jews. This is Friday night at an AmVets or something like that, where like a thrift store, they're trying on, you can't really see it here, but they're trying on military hats. And that was sufficient for the suspension. There was an apology. There's no substantial disruption to the school beyond one parent calling in saying what's going on. There was a news report that the school had been, let's see if I got it here. No, I don't, but there was a news report the school had been, sheriff's office investigated, there was no threat. So the 10th Circuit actually reverses the district court here. The district court says applying Tinker is fine, and Mahanoy has nothing to do with it here. But the 10th Circuit reverses and said, this is controversial speech, but relying on Mahanoy said it's protected. There was no real disruption. And really quickly, I'll just give you a couple other cases, and then I promise I'll stop. Thank you. Courts thus far have found Mahanoy fairly easy to distinguish, right? And most of the claims thus far have not squarely presented Mahanoy issues. Doe v. Hopkinton Public Schools is out of Massachusetts. It's disturbing for another reason. This is two students who were punished for participating in a group chat about a third student on the hockey team. The third student did not know about the participation of the two students who were punished. He was unaware of the posts. There was no disruption. The students only posted 3 or 4 times in an otherwise lengthy group chat, but simply by being members of that group chat and participating in it, they were found guilty. And we argued it was guilt by association, but interesting argument. One final note professionalism cases, thinking about professional standards for teachers, we have ongoing fire litigation on behalf of Kim D.A., who's a pharmacy student at University of Tennessee, who was expelled, and then reversed the expulsion after fire's intervention for her sex-positive posts and under an anonymous name on Instagram and Twitter. And I'll wrap it up there, but stay tuned. I'll have more. I look forward to your questions. Thank you very much.
Thank you, Will, and thank you to all our panelists. We have about 17 minutes for questions and answers, and I think somebody will be walking around with a microphone. So if you can make sure to ask your questions into the microphone, I think just raise your hand if you would like to ask a question.
This is for Professor Duncan. A couple quick questions. One, where does homeschooling fit into your picture? And second, if the government does provide funding to students, to what extent does the government have the ability to try to persuade parents to send their kids to public rather than private schools?
On the homeschooling issue, I think it's a bit difficult I think the public schools could. I think the state could probably limit the vouchers to accredited schools, but a lot of the Arizona law that just came down, the universal school choice law in Arizona includes homeschools at least to the extent they can use the funds to purchase materials and things like that. I personally would include homeschooling in the program, limit it, not so the parents can basically put themselves on an employment salary or anything, but I would limit it to materials. Now, to the extent, how can the public schools try to persuade parents? What type of persuasion are you talking about? Putting out, I mean, they could certainly put out notices saying.
I'm just talking about advocacy. You know, every year when when the money comes out, the question is where do you redeem the money? To what extent can the government, in other words, advertise or try to encourage parents to send their kids to public rather than private schools?
I personally don't think there'd be a problem with government speech saying what a wonderful curriculum we have and what a wonderful program we have in the public schools. Please use your vouchers to send your children to us. I don't think that affects the parents' First Amendment rights, and I think it just simply government speech saying what a great program we have. So I wouldn't have a problem with that.
My question is actually for both Richard and Erica, because based on what I know, I think, in response to Emily, I think that it actually is not incredible that there are students who honestly don't know what a Confederate flag means, given the quality of the education about the history that takes place in the United States. So I guess the question is to what extent it's appropriate to control the content of the curriculum. Of course, as Richard knows, in the Zellman case, the Supreme Court approved of vouchers, but the vouchers included a condition that the school not teach hatred of any person or group on the basis of, and it listed some characteristics. So I guess my question for Richard is whether it's appropriate to do that. And I guess my question for Erica is how important it is to have criteria that refer to the dominant white patriarchy as opposed to just stating specific propositions that the students need to be told of. The history of slavery and segregation, the role of slavery in the Constitution, why the South seceded, why Reconstruction failed, the Great Migration, the economic history that produced disproportionate black poverty in the United States. These are facts. And so I guess I suggest that this is the appropriate thing to push for in the public school curriculum. And my question for Richard is, to what extent it's possible if we're going to support private education. Pierce versus Society of Sisters says you can have curricular requirements that isn't enforced the way that it used to be. To what extent that is appropriate with respect to private education?
I hate to fall back on the word reasonable, but I do think that
the specific propositions I cited, for example.
I mean, I do think the government has the power to impose reasonable regulations covering the kind of curriculum that would satisfy mandatory attendance laws, and I think that's true with respect to private schools as well as public schools. I get a little bit nervous when there are specific viewpoints that are being imposed on the curriculum. So you know, I guess it would really depend upon exactly how demanding they're being in terms of a viewpoint that's being applied. But if the regulation was something like you have to teach all of American history, including the history of slavery, I'd have no problem with that. If the regulation was you have to teach 1619 rather than 1776, then that might well be problematic. That might begin to look like
in response to the question that you posed to me, I think, right on its face, there's absolutely the state can impose reasonable regulations and say the curriculum has to include facts. But what happens in reality is that the education the students were receiving before all of this controversy was never value neutral. And sadly, in many places, we can't agree on what's facts. I mean, I have law students who told me that they were taught in textbooks that the Civil War was the War of Northern Aggression. I mean, I think if one did a survey of traditional social study and history books, there are many problematic things that are in those textbooks that completely went uncovered until this current controversy came about. So I think the challenge really is education is not value neutral. On that, I would agree with Professor Duncan that we are espousing values even when we teach facts. I think the problem is that we can't come to a consensus on whose values we are teaching. And to the extent that this has not been a true multiracial democracy, many of the values that have been taught, at least insofar as race and inequality are concerned, have been values that probably is accurate to say are taught from a particular perspective and paradigm, particularly where I'm at in the South. I'm flabbergasted at what some of my students told me they actually had in actual textbooks that perpetuates a view of a particular ideology or view of the world that is problematic in terms of true inclusion.
So 2 quick questions. Thanks for a great panel. Professor Duncan, if the idea is to allocate the per pupil expenditure to each student, I wonder what is, and this isn't really a speech question, but an equality question differently, what's the basis? Does that happen at the state level, at the national level, at the school district level? And how do you account for both residential segregation and inequality in a plan to try to make parents the drivers of what they want to teach their kids, especially around transportation and all of the sort of things that get in the way of, or that can be barriers to that. And then my question for Emily is, doesn't this doctrine about disruption, and I mean, I've thought this for 20 years, so I'm just asking if you see any ordinary people thinking about it this way, it incentivizes creating disruption. And so instead of the dispute or the topic being sort of rationally discussed, if you want to pursue something, are we incentivizing disruption through the doctrine? And maybe it doesn't matter, but I think it's an interesting question.
Responding to the question about where the funding comes from, I guess it depends. If the court were to hold, which it won't, at least not in the foreseeable future, that there's a constitutional right to equal funding, that decision would have to be implemented with all deliberate speed, because it's a very complicated issue, because funding comes from everywhere. There's local funding, there's state funding, there's some federal funding. So it wouldn't be an easy ruling to implement. It would take some work. But in terms of this coming on at the state level, I think most of where we're seeing the school choice laws coming down, they're not coming down at the local level, they're coming down at the state level. And so they're just providing sort of equal access to state funds, which I think still means, you know, if the state funding part of it is $7,000 or $13,000, I think that would mean that, you know, that families would get the 7, not the full 13 in terms of the way they're doing it at the state level. But that kind of universal school choice law, I think, is still very important. It should be more than a little bit, because a little bit helps me, right? Because I just kick in the rest, but a little bit of scholarship funding doesn't help the poor.
Inner city schools.
It doesn't help the poor, and you know, and I think a lot of the proponents of school choice are inner city families whose kids are trapped in often segregated, racially segregated inner city public schools, and often low performing public schools. And so I think a lot of the support for school choice comes from young inner city families, which are often disproportionately persons of color, families of color who are supporting this. So it's not easy to implement if it's done by a Supreme Court decree. It's easier to implement at the state level because you just write the bill.
And as for the disruption incentive issue, yeah, I mean, I think the current state of the law probably incentivizes administrators to find a disruption. I spend a lot of time telling people to take a deep breath and step back and realize nothing's actually happening.
I personally thank you for that. I want to know, you've identified a crucial flaw in Tinker. The heckler's veto problem, as you describe it, is absolutely present in Tinker. There is indeed an incentive to say, as the burly guy told the cop in the Ferber back in the 50s case with the man on the literal soapbox talking in, I think, Rochester, New York, about racial inequality. The burly guy says to the cop, at least in my mind he's a burly guy, I can't remember if that's actually in the record, but the burly guy says to the cop, are you going to shut him up or am I going to shut him up? And there's a little bit of that still in Tinker, right? If you, let's say someone's flying, you know, Thin Blue Lives flag, and one student says, either you get that out of this parking lot or we're going to burn down that car, right? And tells an administrator that, we got reasonably foreseeable disruption, right? I mean, so, yeah, no, there's a big heckler's veto problem in Tinker.
And normally the heckler is the one who ought to be regulated, not the speaker.
Well, yeah, right. So you've got a line of, yes, yeah, absolutely.
Anyone else have a question?
No, someone's ahead of me. Go ahead.
Sure.
I've already spoken.
I'm like zigzagging through the room. So some of you might know Williamson County, Tennessee, which is where I'm from, and or I live now. But one of the issues that we're dealing with in our district is the regulation of classroom libraries, and I would be curious as to your perspectives, maybe Emily, and then also from a CRT, in creating a space that is for all students. If Ms. Wilson could also speak to that, I appreciate it.
Sure, so I think the classroom library, more than the school library, also raises some academic freedom concerns that I think the afternoon panel will probably touch on as well. But there are more issues there with regard to the teacher being the speaker and having some right to exercise control over supplemental materials in the classroom. Now, when it comes to actual curriculum supplements, courts have said, even where districts have granted teachers discretion, the teacher actually doesn't have any right to use particular curriculum supplements. So the board can always step in there. When it's not a curricular supplement, and the teacher just makes it available, it's a much grayer area. And I don't think we have clear direction yet on it. I suspect we're going to start getting some cases there. But there's certainly an academic freedom argument to be made when the teacher is stocking their own classroom library. And I think we would probably look at similar principles to apply to the school library in terms of what you can put in there. There are restrictions on what can go into a school library when you get to really extreme material that wouldn't be appropriate for the K-12 audience. Those same rules would apply to classroom libraries, and beyond that, I think we're gonna see soon where courts want to come down on this. But I think there are legitimate academic freedom arguments to be made there.
Yeah, I would agree with everything that Emily said there in terms of academic freedom, particularly for teachers in their own libraries. One thing that I've started to think about, because we've had some of these issues in North Carolina as well in terms of book bans and regulations in the classroom, is whether or not there's actually an offensive attack to be made on equal protection grounds when you look at the books that are being excluded and the students who are being impacted by the exclusion of those books. I mean, pretty innocuous books, anything with a Black author or Black subject in some of our counties is being deemed as something that shouldn't be in the classroom. So I think part of the challenge in terms of this legal and political fight is not always being on the defensive and making some offensive claims as well.
Just to weigh in on Professor Wilson's good point, there's litigation right now, both in the state of Florida against the quote-unquote Stop Woke Act. FIRE has a lawsuit there. We're litigating alongside the ACLU. The ACLU, as I recall, did bring an equal protection claim in that context. There's also an Oklahoma case, again, brought by the ACLU, which I believe also has an equal protection claim with regard to bans on quote-unquote divisive concepts. So, yeah, stay tuned.
We'll take one last question.
So just a thought about strategy here. I think that I agree with Erica that there's no value-free education. There's no value-free history. There's just way too many facts in the past, and so you've got to pick and choose which facts from the past you are going to teach. I mean, the deep problem with at least some of the anti-CRT legislation is that it prohibits teaching certain things that are true because teaching things that are true could be divisive. So it's just going back to the ignorance about the meaning of the Confederate flag. There are people out there who think Confederate flag means I'm a rebel, and that's all that they don't know any history, they don't know anything, So I think that the ground on which to fight is to say, well, is it okay to include in the curriculum, for example, the South Carolina Articles of Secession, where they say, this is about there's a president who's against slavery, and we can't endure that. And they say we're seceding because of slavery, because we need to keep enslaving African Americans. That's what we are fighting about. There's a value judgment about whether students need to be taught that, but I'd really like to be fighting with the people on the other side and put them in the position of saying, no, that's a fact about which it's important to us that Americans remain ignorant.
All right, well, let's call that the last word and end our session. With that, thank you for
There's like it's like it's crunchy. Oh, interesting. I think it's only the first page. It's probably because it's, or is it redacted beyond the first page? I think they redacted so more info if I remember correctly. Okay. Oh, it's not even open. Yeah. How weird. Okay. What's the case citation? I can try to pull it. I wonder if it will info, or it was like a competitor. It was kind of like the head notes, or yeah, that might have been it, something like that. But I don't know if that's what this is or not. Yeah. Okay. On mine, it's just the first couple pages. So, do you want me to send it to you? Sure. Yeah. Yeah. Very weird. Yeah.
Yeah, exactly.
Okay. Thank you. Appreciate it. That's so weird on mine. Yeah. It was like. Cute. That's really cute. That's so extra. Like, I know. Maybe it's an IP thing? I don't know. Oh, maybe. It seems over the top. I've never seen that before. No, I only saw it like one time. So, I think.
Yeah.
His reaction.
Well, I'm the chair right now of sociology, and we have 4 hires and blah blah blah. But I.
No worries. Thank you.
Sorry? 3 minutes?
She's hard to hate.
Yeah, no. Yeah.
Why are you here? As bad as I if there's people like still kind of out there, but then otherwise But oh yeah.
I'm not taking a seat.
That's not fairly comparable.
Adversely positioned.
Good afternoon, everyone.
Good afternoon.
Hi. My name is Andy Geronimo. I'm the director of the First Amendment Clinic here at Case Western Reserve University School of Law. I'm delighted to welcome you all to the second panel of our Law Review Symposium, America's Classrooms, Frontlines of the First Amendment. We're mostly going to be focusing on higher education in this panel, and I'm delighted to have the panelists that we have with us here today. I'll just go briefly through some of their, introduce them and their biographies, and then I'm going to ask them to speak a little bit about their symposium piece or their practice or other research on this topic, and then hopefully we'll be able to have a little bit of discussion and maybe some questions, I hope, at the end. First, remotely via Zoom, we have Professor Caroline Corbin. She's a professor of law at the University of Miami School of Law, where she focuses on U.S. constitutional law, the First Amendment, the religion clauses, the free speech clause, feminism in the First Amendment, and advanced topics in reproductive justice. Her scholarship focuses on the First Amendment speech and religion clauses, particularly their intersection with equity issues. We're also delighted to have Keith Whittington, who is the William Nelson Cromwell Professor of Politics in the Department of Politics at Princeton University. He's the author of Repugnant Laws, Judicial Review of Acts of Congress from the Founding to the Present, which won the Thomas M. Cooley Book Prize, and Speak Freely, Why Universities Must Defend Free Speech, which won the Prose Award for Best Book in Education and the Heterodox Academy Award for Exceptional Scholarship. All of these folks have much more distinguished biographies that I'm going to race through in service of us having a little bit more time to talk. We also have Professor Laura Beth Nielsen, who is a research professor at the American Bar Foundation, as well as professor and chair of sociology at Northwestern University. She's a sociologist and a lawyer, and she has degrees from the University of California, Berkeley. We also have Andrew Koppelman. Professor Koppelman is John Paul Stevens Professor of Law and Professor by courtesy of Political Science and Philosophy Department affiliated faculty at Northwestern University. He received the Walder Award for Research Excellence from Northwestern, the Hart Dworkin Award in Legal Philosophy from the American Association of Law Schools, and the Edward S. Corbin Prize from the American Political Science Association. And finally, we have Shannon Minter. Shannon Minter is the legal director of the National Center for Lesbian Rights and one of the nation's leading advocacy organizations for lesbian, gay, bisexual, and transgender people. I'm going to ask them to start with a little bit of a dialogue about their interest in this area. We're going to start with Professor Corbin, then move to Professor Whittington, then Professor Nielsen, and then Professor Koppelman, and then Mr. Minter. So without further ado, please. I believe you're muted. I'm sorry, I think you're muted.
I'm there. Sorry about that. I'm sorry. It's a little. There's a little bit. I'm having some technical issues. There. Okay. You can hear me?
Yes. Loud and clear.
Excellent. Can you see my slides? Yes.
Yes.
Okay. All right. Start the clock. All right. So I'm really excited to have the opportunity to present to you today. In a nutshell, my paper argues that K through 12 public school teachers do not have a free speech right to misgender students in class. They don't have it as a matter of current doctrine, nor do they have it as a normative matter. So I'm sort of a bridge between the first one and today. So just some basic background on transgender kids in the classroom. In the United States, sex is assigned actually way more complicated than that. The sex method works for most people, but not everyone. So for roughly 1.4% of today's youth, the sex assigned them at birth does not match their gender identity, but they feel what they know their gender to be. And transgender kids have a really rough time of it. For example, they have distressingly high depression, suicide rates, constant harassment at school doesn't help, and this affects their education. One study found that transgender students with higher rates of harassment at school were more likely to skip classes and get lower grades than transgender students who were less harassed at school. Studies also show that gender affirmation alleviates the mental health risks of transgender children. So, for example, one study found that for each additional environment that affirmed the gender with the correct pronouns, and school was one of those environments, depression dropped and attempted suicides fell by 50%. So gender affirmation in the classroom presumably also improves educational outcomes. Not only do the students' mental health improve, but if they're feeling more included, they'll be more likely to participate and less likely to cut class. So the first point I want to make is gender affirmation at school and in the classroom is crucial for the well-being and education of transgender students. And some of you might have even started to ask your students what pronouns they use for precisely this reason. All right, what about the teachers' free speech rights in the classroom? So generally, government attempts to control the content of someone's speech are presumptively unconstitutional. There are content-based regulations of private speech. They trigger strict scrutiny that they rarely survive. After all, the point of the free speech clause is to prevent the government from dictating what we can all say or hear. In contrast, content-based regulations of government speech, as opposed to private speech, trigger no free speech scrutiny whatsoever. Under the government speech doctrine, government speech is outside the free speech clause. The free speech clause protects private speakers from the government, not the government from itself. And you might think that the teacher's classroom instruction is really a little bit of both. But as a matter of doctrine, it's probably government speech. When a government employee brings a free speech challenge about speech at work, the first question asked is whether the speech is pursuant to official duties. That is, was it uttered in the course of fulfilling ordinary job responsibilities? So it's not, speech pursuant to official duties is not just speech at work or about things learned at work. It is speech that is the work itself. And if it is, then it's considered government speech and therefore outside free speech protection. And I think few would or could dispute that teachers teaching in their classroom is speech pursuant to their official, ordinary job responsibilities, and calling on students is part and parcel of their teaching, and so they lose, right? Misgendering is essentially the government's own speech because it is pursuant to official duties, and therefore the government has complete control over it. This seems really straightforward. Why write a paper about it? And one reason is that there may be an academic freedom exception to speech pursuant to official duties. And indeed, the Sixth Circuit awarded victory to a professor on the grounds that academic freedom protected his right to misgender his students. So does that mean that K-12 teachers should also win? As a matter of law, there is no academic freedom doctrine that protects K-12 teachers. So first, it's not clear whether there's any academic freedom doctrine. Garcetti, the case that established that pursuant to official duties rule, acknowledged the potential carve-out from its rule for academic freedom, but it didn't actually hold that there was such a carve-out. So it's very much an open question. Second, if it exists, it's generally, the courts have talked about it at the university level, not at the K-12 level. And third, when lower courts have really applied it in situations where there's tension between the institution and the individual instructor, they've generally found that the right belongs to the educational institution rather than the individual professor. And finally, even if it is a right for individual professors, it's generally understood to protect research and scholarship, something that K-12 teachers generally do not engage in. So as a matter of existing doctrine, K-12 teachers may be out of luck. In any event, as a normative matter, academic freedom is not designed to protect something like misgendering, regardless of what educational level you may be. So the American Association of University Professors, their view of academic freedom is the most widely adopted one. And they absolutely support academic freedom for individual professors in their scholarship and in their teaching, as do I. I'm a professor, of course I do. But even the AAUP does not view academic freedom as carte blanche for teachers to say whatever they want in class. So first, for teaching, academic freedom protects teaching on the teacher's area of expertise, not any random topic they feel like opining on in the classroom. And frankly, the topic of gender identity is not an area of expertise for the French teacher, math teacher, orchestra teacher, or other teachers claiming a free speech right to misgender. Second, speech protected by academic freedom ought to meet certain professional standards. Otherwise, it's a real disservice to our education and our search for knowledge, which is ultimately the reason for academic freedom. In other words, academic freedom ought not protect speech that is really considered just anti-knowledge, that would fail the most basic peer review. And frankly, the scientific community has rejected the idea that sex is binary. So, just as a math teacher doesn't have academic freedom to tell students that the earth is flat, an orchestra teacher does not have academic freedom to interject scientific fallacies into the music classroom. And third, the AAUP underscores that academic freedom is meant to protect teachers and students, let me repeat that, is meant to protect teachers and students in the classroom, and that professors have a responsibility to their students. And at the very least, they should not be creating an unwelcome classroom environment, which deliberate misgendering does. Indeed, it's also contrary to every educator's ethical obligations towards their students. But even if academic freedom somehow reached misgendering, it still should not win because there are a couple of more requirements in government employees to show to prevail on a free speech claim. And that includes that the speech has to be on a matter of public concern and the speech cannot be unduly disruptive. And misgendering satisfies neither of the second nor the third. So again, under existing doctrine, government employee speech, like public school teachers, or actually public professors, is only protected if it's on a matter of public concern. That is, it has to be valuable in some kind of way to audiences. And the topic of gender identity, that's clearly a matter of public concern. But the teacher using the wrong pronoun when calling on a student is not a discussion on gender identity or even inviting one. Really, it's more a teacher imposing a view they don't believe is subject to debate. So I argue misgendering is not actually speech on a matter of public concern. And finally, the speech is highly disruptive. It undermines the mission of the public schools. And what are they? Well, first, they want to teach certain academic knowledge and skills to prepare students for a life of financial independence. And second, public schools are meant to instill certain values to make students citizens. So starting with learning academics. Learning today is all about active learning, right? Students grappling with material is crucial. They have to answer questions, ask questions, engage in debate. Misgendering and the unwelcome environment it creates discourage participation, which is that key ingredient for student success. Schools are also meant to teach certain values, and one the Supreme Court has repeatedly emphasized is teaching and modeling for students socially appropriate behavior generally, and the rules of socially appropriate civil debate specifically. And that includes addressing people with respect. And again, intentional misgendering is the opposite of that. Indeed, it's not just inappropriate, it's harmful. Never mind that misgendering may actually amount to illegal discrimination that violates Title X, whether because it's denying people access to education or creating a hostile school environment. And finally, the government's interests are particularly strong when it comes to the students entrusted in their care. First, students are a captive audience, and even for private speakers, the right to speak may be curtailed when a captive audience does not want to hear it. And the students in the classroom are about as captive as it gets. Right? Again, I'm talking about students in public schools. They're required to be in school, they're required to be in class. And finally, students are particularly young and impressionable. They're subject to the influence of their teacher, who has sway over them, both as a role model, but also the person who has power over them, who can punish them and grade them. So I say the school interests apply with particular force to young, impressionable, captive audience. In sum, do public school teachers have a free speech right to misgender? I say no, they do not, and nor should they. Thank you.
Thanks very much. Professor Whittington.
So thanks. I appreciate the opportunity to be here and talk about this. I was a little nervous that my paper was going to be more distant than some of the others to the classroom context in particular, but I've been pleased at one level that there's already been some overlap with some of the issues that I want to address as well, and so in part I want to build on that now. I'm particularly focused on extramural speech, which gets called in the academic freedom literature extramural speech by faculty, which is to say when professors speak outside the classroom context, outside the scholarly context, and most literally off campus, although the subject matter may be on various things, but in general on issues that are of general public concern. The American Association of University Professors advocated for really three different kinds of speech that are protected by academic freedom principles in the early 20th century and that most American universities have subsequently embraced. One is protection for classroom teaching and being able to talk about controversial subjects with your students in the class without repercussions from your university employer. The second relates to research and the ability of faculty to engage in research without censorship or retaliation from their university employer. And then the third is this category of speaking as a citizen about matters of general concern. Often this gets pitched in terms of speaking outside university context, but there's also intramural speech that occurs on the university campus, but is also about matters of general public concern. But the key issue here is you're speaking, as the AUP puts it, as a citizen, not necessarily as a scholar. Which may mean that you may be talking about things relating to your academic expertise, but you may be talking about things that have nothing to do with your scholarly expertise more generally. That professors hold political opinions just like everybody else, or maybe even more so, and this is designed to protect their ability to engage in political discussions as well as other kinds of discussions more generally. This extramural speech component of these traditional protections is of increasing salience over the last several years, in particular with the rise of the internet and maybe even more particularly the rise of social media. It makes it easier for faculty to engage in broadly communicated acts of extramural speech. And as a consequence, their speech, one, doesn't have to go through the kinds of gatekeepers it might once have had to go through, and two, can encounter a much larger and more diverse audience than might once have been the case, and as a consequence, professors often find themselves in trouble for having said controversial things in earshot of the general public. These traditional AUP principles are designed to protect that. In addition, there's a First Amendment framework that particularly overlaps here, and that it's more complicated as to how to think about First Amendment in the context of the first two components of academic freedom, the scholarship and the teaching. But the extramural speech actually integrates fairly neatly with First Amendment doctrine, in particular, as we just heard both this morning and just now, relating to the Pickering case. So the Pickering case from 1968 relates to government employee speech and what kinds of First Amendment protections you might have in that context. As has been mentioned, there's initially a threshold question about is the speech involving something of public concern more generally, more of a Garcetti more recently has emphasized as well that it needs to be speech that is not pursuant to official duties, although there may or may not be a carve-out for academic freedom concerns. I am particularly interested in those issues for the classroom speech context, and I've written separately about the implications for the critical race theory bills and what the implications of Garcetti and Pickering are for thinking about some of that. But here I can largely set aside because my focus is not on what people say in the classroom, but what people are saying, for example, on social media more generally. Once you've made it through that threshold matter and you think this is potentially something that there's a First Amendment interest in, Pickering then says, well, now there's a balancing test. What's the individual speaker's interest as a citizen? How does that weigh against the government's interest? And as Garcetti, or as Pickering particularly put it, the government's interest in promoting the efficient delivery of governmental services. So the court recognizes that a government employer has particular interest in regulating the speech of their employees. This is different than the government acting as a sovereign trying to regulate the speech of its citizens more generally. And as a consequence, in that context, the government as an employer has a much more robust set of interests that might restrict even First Amendment protected speech by government employees more generally. So the focus of my paper really is trying to think about how should we think about that balancing test. So once you've made it through that threshold, you're in the context of balancing, and you're doing it in the context of a state university professor who is engaged in extramural speech, so not classroom speech that's occurring in public as a citizen. It's a state university professor, so it's a professor who's protected by these First Amendment interests with a governmental employer. I think these kinds of issues are also illuminating for thinking about the private university context, because the extramural speech concerns are so similar to the Pickering concerns. But there's a particular stake here in thinking about how should courts think about this kind of balancing test. And I'm particularly driven to it both because I think that in trying to think through these extramural speech debates generally, it'd be helpful to think more systematically about the kinds of balancing the court has emphasized in the Pickering context. But in addition, I have real concerns about how courts in fact deploy the Pickering balancing test in the context of state university professors. A lot of both the Supreme Court doctrine, but also certainly lower court decision-making relative to Pickering balancing does not involve university professors. Instead, it gets articulated in terms of lots of other governmental contexts and lots of other kinds of government employees, including sometimes K through 12 teachers. And one of the challenges for university professors then is the same kind of arguments that get successfully deployed by the government when they're talking about police officers, for example, or kindergarten teachers. Should those also be imported over and thinking about state university professors? And so the concern of the paper is to say generally not. Generally, there's a whole different set of interests that ought to be considered when we're talking about the university context that makes the kind of balancing that would occur quite appropriately in the context of other kinds of governmental agencies quite inappropriate if applied in the context of state universities. And as a consequence, there are very few considerations and interests, I think, in which the state might quite reasonably say we ought to be able to outweigh the professor's First Amendment interest once you get into this context of balancing. So the paper lays out three kinds of issues that frequently get raised in these balancing contexts and looks at them as they've been deployed to some degree in the context of university professors and how I think we ought to be thinking at them more generally. So let me just mention them very briefly just to get them on the table. So one is you've seen some arguments both the universities are raising, but you also see it in some of these court decisions as well. A concern about thinking about the best interest of the university more generally. Can the university effectively deliver its services, and what is in the interest of the university more generally, and when do faculty and their extramural speech potentially run up against those interests, and how should they be balanced? To give you one example in which this has come up quite prominently lately is in Florida. So Florida has a myriad problems on the academic freedom side these days. But one of their problems is that the University of Florida tried to restrict the ability of some professors at that university to participate as expert witnesses in a lawsuit being filed against the state challenging the state of Florida's voting rules. The University of Florida requires faculty to get approval for outside activities they might engage in, and the University of Florida denied the request of these faculty to serve as expert witnesses because the University of Florida concluded participating in a lawsuit against the state of Florida, in particular against the executive branch of the state of Florida, is adverse to the interests of the university. And as a consequence, a university employee should not be able to participate in that. I think fundamentally this misunderstands both what ought to be, constitutionally speaking, understood to be the interest of the university more generally, and if we were to run with that kind of logic, it would have sweeping consequences for the ways in which universities can regulate speech that we think quite appropriately faculty ought to engage in. And one starting point for thinking about this is that the universities in particular ought to be understood as having a brand, having a particular institutional purpose, precisely in order to generate varieties of competing and often controversial arguments and ideas, including ideas that run against the political interest of current incumbent governmental officials more generally. So if you told university professors that if you engage in speech acts they're contrary to the interest of the current governor of Florida, for example, you are sharply limiting what it is we think universities ought to be doing at their very core mission. And as a consequence, if you're trying to say, what's the mission of the university we're trying to protect here, this is a misconception of the nature of the mission in order to employ it in this particular context. A second kind of argument, which we just saw mentioned, for example, that's frequently deployed in these Pickering balance issues, is questions of disruption. So the courts have repeatedly said that you can, as a government employer, sanction and even terminate disruptive employees in various ways, and that their First Amendment interest in speaking, and that's part of what's causing the disruption, does not protect them from the ability of being sanctioned in these contexts. As was mentioned earlier, there are serious heckler veto problems with this kind of concern. We might think the heckler veto problem is not a big problem in a variety of contexts. So, for example, courts have said if you're a police officer and part of what you're doing is speaking out in public in ways that are offending the citizenry and make them very nervous about the police in general, this is contrary to the general interest of the department. The department, as a law enforcement agency, has an interest in maintaining a good reputation of the department with the community. As a consequence, certain kinds of government employees have an obligation to make sure the public maintains a high opinion of those employees, as well as the agency more generally. Moreover, this has been argued in the context of K-12 education as well, where there's a concern saying precisely you have to have a cooperative relationship with parents, and as a consequence, if you say anything that's offensive to parents, that undermines the ability of the schools to function effectively and for you to function as a teacher effectively. And as a consequence, governments can quite properly take that into account in punishing you for engaging in that speech. I think that's completely wrong, though, if applied to the context of university professors. It might be wrong in some of these other contexts as well. I'm more concerned here trying to distinguish the context of university professors. That we deal with adults rather than small children, for example, so we're not trying to maintain good relationships with parents in the same kind of way. And likewise, as I noted, the whole point of the university is to talk about controversial ideas. And so in that sense, maintaining a good public reputation by only talking about the non-controversial ideas runs counter entirely to the very point of a university. So the kind of disruption that governments, I think, can reasonably take account on university campuses is a very narrow kind of disruption and does not result from the reactions others might have to the controversial speech, but instead revolves around, and there in fact are lots of examples of this from the late 60s and early 70s, where courts were first encountering it, professors engaging themselves in disruptive protests. So if professors are inciting students to occupy a government building, for example, that's a quite reasonable kind of disruptions that universities ought to be able to take into account and can fire you for engaging in. On the other hand, if students don't like something you've said and then they sit in on a government property, it's the students who ought to be a concern here, not the faculty member who said the controversial thing in the first place. And finally, a third category that I'll just mention is a concern about fitness. As was mentioned before, one of the constraints on extramural speech is if you engage in public conversations that demonstrate you're incompetent as a scholar in your particular area of expertise, that's a problem from the university's perspective. The AUP has emphasized that the extramural speech should not be the linchpin of thinking about your scholarly competence, but it may signal there's an issue here that the government ought to look at more closely. But certainly I think the government shouldn't be leaning heavily on that kind of extramural evidence. So if you say something really stupid on Twitter about something that you're supposed to be a scholarly expert in, the university might quite reasonably say, are you saying the same stupid things in the classroom when you're trying to teach students? And the university might want to investigate that. But if they find, in fact, that your classroom speech is totally competent, your scholarly speech as such is competent, and you're just saying incompetent things on Twitter, then they should not be able to punish you for that. And more recently, we've also seen concerns of saying, well, there's another element of fitness that's potentially concerned, which is one of bad character. So not only are you showing that you are incompetent by speaking in public in stupid ways, but you're also showing that you have a bad character. You're being mean to people on Twitter, and we ought to be able to fire you for that as well. And again, I think this is an area in which universities have to tread extraordinarily carefully. There ought to be only very narrow circumstances in which we take that kind of extramural speech as informing the university's proper judgment about whether or not you're properly fit to be in a classroom with students, for example. So I think that Pickering is very useful in trying to think through some of the issues associated with extramural speech. That's true in the private university context as much as the public university context. But it's useful as well because it emphasizes the ways in which university professors are very differently situated than lots of other government employees. And as a consequence, a lot of the same logic that works when we're talking about other kinds of government employees and other kinds of governmental agencies don't work very well if what we're talking about are state universities and faculty. So thank you very much.
Thank you. Professor Nielsen.
Thank you. Thanks for the invitation to be here today and to be part of these really interesting conversations. I'm accustomed to going around after 20 years researching and debating scholars in the US and around the world, talking about the new sort of crisis du jour in free speech in academia, and this is it's what I love. So while there's a familiar pattern and a familiar set of rules and standards that we are always evolving, spoiler alert, I don't think we're in a crisis around free speech. We're in yet another moment where students, faculty, and society have to figure out a way to preserve relationships and civility in changing times. I'm not saying that we're necessarily super great at that, but we've been trying this for a while. Now, before we start, I want to acknowledge my graduate students, Elsinore Kuo and Evan Zhang, who have assisted with my research on this paper and will be authors of the final paper if they choose. Since we're diving into issues of identity, I should tell you that I'm a cis woman, and given the topic, I guess I should also tell you that I am a Christian. My graduate students are still deliberating on what they'll say in their authorship footnote, and I mention this not just because it matters who's talking about these issues of identity, but it illustrates yet another set of professional difficulties for minoritized people in academia. As a sociologist and legal scholar, my talk will be a little bit different today than the others. I'm interested in the specificity and the jurisprudential arguments that we've been talking about, but I also think that more of a 30,000-foot view is often needed in order to see what's actually being claimed and what's actually not so neat and tidy in our jurisprudential debates. Power and violence are always part of my analysis, and that requires me to be attentive to the social world in which the actors are operating who are bringing these cases. So here you see history being made with Laverne Cox, the first trans person ever to grace the cover of Time magazine. We enter this discussion in a particular social moment. The 2016 election revived, or at least rendered visible, the fact that dehumanization, racism, sexual assault, and mockery of people with disabilities can still serve as a rallying cry to unify enough Americans, though not a majority, to elect a president. Hate crimes are on the rise. The categories change, but hate crimes are on the rise. Overt white supremacy has been rebranded as alt-right, and we know that trans people, which will be the subject of my talk today, have a vastly higher both suicide and murder rate. We're seeing a revival in violent murderous hate crimes targeting minoritized groups, and here I just have 3 examples. The January 6th Capitol riot, the Unite the Right rally in Charlottesville, and the Black Lives Matter uprising just a few miles from my home in Kenosha, Wisconsin, after the murder of George Floyd. These events reveal new importance for empirical research about hate speech and its links to systematic violence and other kinds of harms. So I'm going to tell you today what the research shows us about misgendering. And I will argue that all 3 of these kinds of analysis, doctrinal, empirical, and social theoretic, are required to really understand what's at stake in these debates. Our tendency is to isolate speech debates to facts, which I know is the law school way. I went to law school. But it can serve to hide the patterns of what I'm going to argue are really going on, and also encourage us often to talk past each other rather than trying to talk to each other about these difficult topics. Okay, so first, some legal context. It takes me a while to convince my undergraduates, but I expect you all understand that local, state, and federal law limits speech all the time, all kinds of speech, commercial speech, obscene speech, slander, libel, panhandling, verbal sexual assault, sexual harassment that rises to the level of a hostile work environment in some circumstances, inciting lawless action, without First Amendment problems. I won't say they never have them. There are certainly challenges, but we understand those to be regulable. And how do we do it? Just like everybody's been talking today, we balance the interests of the speaker, we balance the interests of the government, and I would argue we need to think in a very Durkheimian way. We need to also think about the interests of the onlookers. When we balance harms, when speech is constructed as hurting someone's feelings, or even 100 people's feelings, the idea that we would limit speech seems really kind of ridiculous, or religious freedom. But I want to broaden the focus. And so here I'm going to talk about intentional misgendering in its broader social context, and then in the classroom itself. So legally right now, we tell members of traditionally disadvantaged groups like trans and non-gender conforming people that the regulation of hate speech is unconstitutional except under very limited circumstances. Cross-burning is protected unless it's done with the intent to intimidate. College women at an orientation event are told that a crowd of fraternity boys chanting no means yes and yes means anal under their dorm window, which by the way is on a college campus. So the idea that these spaces are somehow neatly divided is, makes for difficulty in the analysis. It's something they must tolerate in the name of free speech, even if it makes them less full participants in the scholarly community. And trans and gender nonconforming people are told that they need to tough it out when being bullied in school, even when the bully is their professor. At the same time, we see a regime of free speech that protects the powerful, privileged, and popular. In judicial circuits where panhandling regulation is permitted and has been for decades, part of the justification of that is that working commuters and business people have an interest in financial, commerce, all of that sort of stuff, for people to be in public without being harassed. Chambers of commerce and city governments are interested in presenting customers and consumers with easy to traverse spaces not sullied by people asking for money. So workers, tourists, and consumers are protected from requests for money. I could talk about the Westboro Baptist, but for the sake of time, I'll move along. This is just to say that not all speech, even in public, is treated the same way by the courts. And if homeless vet is not a political speech, I don't know what is. Westboro Baptists, of course, were granted free speech right to protest soldiers' funerals, which was then overturned, congressional override. The Supreme Court can't be overturned, but there was congressional override of an act that did then go on to protect soldiers' families without a word of protecting gender nonconforming and gay people. So our veteran here can be arrested. The policy driver here is a conception of harm. And when we think about one particular event, it might not seem so harmful, but continually harassing members of disadvantaged groups is not speech, I would argue. It is doing something, it is resulting in harm. It is the harm of inequality and subordination. A lot of the talk today here has been about equality, like equality in funding for public education students versus private, equality of professors across different kinds of categories. And I would argue that in addition to silencing, allowing professors to misgender their students creates inequality. Just like we understand this possibility in the workplace, how come we don't understand it in the law school classroom or the college classroom? So now I want to tell you some things about systemic repeated misgendering. This is social science evidence. This is not my normative take. This is research from sociology, psychology, education. All these disciplines have different models and methods, and thank you for setting me up so well. But these are the social facts. What is it like to be trans-identified in our current social world? So the chart on the right, or the table on the right, is by Danya Lagos. It'll appear in American Journal of Sociology. It's out online, but not in print yet. And it shows us the identification of trans or non-binary people. And identifying in such a way is growing dramatically among along both cohorts. And yet, look at the y-axis. We're talking about less than 1% of the population, even in the most recent times. Now, this doesn't include, I think this goes to 2002, so presumably it will continue rising once those now children or minors are included in these cohort studies. But it's a really small minority of folks. I don't think anyone would argue that. And they're being targeted by a powerful and largely Christian-identified people and organizations. So leaving murder aside for the moment, I want to talk about misgendering as targeted persecution. Unfortunately, religiosity in general is highly correlated with prejudice against LGBT people, support for bathroom bills prohibiting trans people from using the bathroom that matches their gender identity, support for prohibitions on speech in public schools, and prohibitions on trans athletes competing on teams that match their gender identity. Thank you. Also, religiosity predicts disfavoring the government allowing non-binary gender markers to government documents like driver's license. And yet, the ordinary people, when you poll them or study them who support anti-trans causes, the rationale for doing so is not largely framed as religious. It's framed as the right to discriminate, and yet the legal claim being made in these cases is religious. So let's talk about who's pushing the agenda. So these are the three primary litigating organizations. It's a surprisingly small handful of organizations who are responsible for the recent preponderance of religiously justified attacks on pro-LGBT policies. There's the American Family Association. I think they're the middle. I tried to get that picture. That orange part was talking about persecution of Christians. But they primarily operate through boycotts. They've boycotted Target, PayPal, Walgreens, Dove, usually in reaction to corporate policy changes that permit trans people to use bathrooms matching their gender. The Liberty Council, which is the one on the right, is a nonprofit organization which engages in lobbying and provides pro bono counsel advancing religious freedom, the sanctity of life, and the family. They were involved in Madsen versus Women Healthcare on the side of abortion protesters who wanted to protest at the homes of abortion providers. In 2003, the Liberty Council also filed in Lawrence versus Texas and to uphold Texas anti-sodomy ban. No, you know what I mean. And more recently, they threatened to sue on behalf of concerned parents when a Wisconsin school planned to read I Am Jazz, which was the book that the first speaker had up. And by the way, Jazz is from Evanston, Illinois, where I live. I'll skip all that. Finally, the Alliance for Defending Freedom, a nonprofit legal interest group. And just to give you a size and scope of these organizations, their total assets exceed $48 million, with a total annual revenue last year of $187,000. They claim to support minority religious beliefs, but make frequent reference to Christian and especially evangelical Christian imagery. They also supported the recriminalization of homosexuality in India and Belize. And of course, this organization represents Meriwether in the case of misgendering in the college classroom in a class that had nothing to do with identity politics or law. Now, this slide is not meant to be read. You're welcome. But this is the research evidence, and we'll go through it all in the final version of the paper that comes on. But it's to point out, as Professor Corbin showed us, that while it's scant compared to the evidence about the harms of racial microaggressions and sexual harassment, there is enough of an academic and consensus across broad fields, medicine, psychology, law scholarships, sociology, political science, that shows that intentionally misgendering trans students undermines students' physical and mental health. Those effects are long-lasting. They don't just happen in the classroom for 1 minute. Stigma-based bullying has the most significant harms for minoritized groups. So when it's about the identity characteristic, there's not a lot of research on it yet, but we know when that happens around race that academic performance declines. And then in the classroom, we know that it increases hostility, fear, it decreases academic performance, it ups your odds of dropping out, as does sexual assault, in case you're interested. And misgendering has been singled out as the most frequent form of harassment that college and graduate and professional school students experience at school. Survey research shows that the lack of support for trans students identifies and harms their academic self-concept and makes them less confident and motivated learners. In law school, Meriwether's not a law school case, but I would argue in the law school, what we know about it excluding people from the law school community, it also means misgendering and the subsequent harms will lead to failing to connect and make the kind of social networks that we all understand law school as being part of the reason that we go for. But it also makes these students unable to learn. And, thank you, the sense of belonging in the university and law school community is hurt when the person in the position of authority, remember I said we were going to be talking about power, it's not just misgendering by other students, it is by the person in power. The lack of affirmation, the lack of affirmation inhibits the ability to focus on their studies and to develop healthy social lives. So, misgendering also places trans students in the uncomfortable position where they're forced to be vocal and vulnerable to harassment. Self-advocates and educators on the topic of gender, for example, that it is not binary, in order to participate in the communities. Taken to its extreme, are we going to begin to ask people to show us their genitalia or their DNA results? I don't think anyone in this room thinks that's reasonable. So if you're told I am a man, how are you going to tell me that I am not? Okay. Misgendering across the board also has been linked to severe mental health issues, which Professor Corbin went over, high risk of suicide, even controlling for other experiences of trauma, right? So the research has been very good about controlling for other sources of trauma, as well as how often you are misgendered or that you feel you've been misgendered, sort of like the research on racial microaggressions. Leads to PTSD, riskier sexual behaviors, anxiety, psychological distress, eating disorders, suicidal ideation. Linguistic anthropologist Elizabeth Mertz demonstrates that part of learning to think like a lawyer in law school it comes at the expense of a unified classroom environment and is associated with less participation by minoritized groups. She doesn't include trans, but racially minoritized. So let's return to the idea of religious freedom protected by the court. I'll spare you the cases that we've been mostly hearing about today, where Christianity or the idea of religious freedom around Christianity is upheld, and talk to you about this. So here's where I hope you're at. You're thinking, these are terrible harms. No human being should have to suffer that. I think that. And I think it's a Christian belief. And you might even be convinced that the First Amendment doctrine about speech is inconsistent at best, as I've shown you, to protect the privileged and the powerful. But still you might be thinking, Lord Beth, religious freedom is really important, and the court needs to protect those claims. So I'm not going to give you the recent abortion decision or even Hobby Lobby. I'm going to ask you to consider Goldman versus Weinberg, in which the Supreme Court upheld military regulations forbidding soldiers from wearing religious gear. In that case, it was a yarmulke. I couldn't really find a good picture of that exact plaintiff because I don't know why, because it was a while back. So I put this woman wearing a headscarf. It was congressionally overridden, but we're in a law school, so we're talking about the courts. The Supreme Court thinks it's okay to restrict religious expression for Jewish people in the military who want to demonstrate their religiosity through garb. And the second is Oregon versus Smith, very famous case. That is the actual Smith, where the Supreme Court upheld a restriction on unemployment benefits. So he took peyote as part of a religious ceremony. The Supreme Court said, we will say for the sake of argument that we accept that this is a religious practice of that you have, and nonetheless you can be fired and not receive government unemployment assistance when you show up with a drug test. So, in addition to context, these kinds of contexts, I want to think particularly about the classroom. The classroom is a place to learn, and it's a place where we as faculty members have obligations that go. The Merriweather case in a lot of ways is really easy. It is not a class about gender. It's not a class about sexuality or politics. And in that way, the importance of the professor to do their job is eminently possible. In fact, in this case, there was a compromise that was accepted by everyone, and yet we still end up with this case because of a failure to, failure to accept that compromise that could have worked in this classroom environment and had the person be gendered in the way that they wanted to. So I'll just say, law matters, but so do space, right? The idea of the university as a place where people live, a place where people work, and a place where people learn. And identity are all sort of combined and interacted. So we celebrate difficult cases like the Westboro Baptist, Nazi hate speech, KKK cross burnings, but considered through the lens of space, place, identity, social power, what we see is really the argument for freedom. The argument to not be misgendered is not un-American. The argument that professors should have an obligation to do their job and teach is simply asking public school teachers, in this case professors, to live up to the promises that it makes about equality but has not yet fulfilled for minority groups. Thank you.
Thank you. Professor Koppelman, please.
So when I wrote my paper, I didn't realize that so many people were going to talk about transgender issues and the Merriweather case, which it's actually not the only thing that I'm going to talk about. I'm going to talk about a pair of cases that are unified by the actual title of my paper, The Emerging First Amendment Right to Mistreat Students. As America becomes more polarized, with the polarization tracking religious differences, it becomes more urgent to tell a story of who Americans are in which each faction can recognize itself and see a home for itself. We need to make space for people who have radically different ideas of what counts as a good life. Rick Duncan talked about this a bit. The classic Lockean liberal answer is to draw clear boundaries to create a private sphere where citizens are free to exercise their religion in ways that other citizens find repugnant. There, I think, is some work that still needs to be done about the relationship between Locke's theory of property and his theory of religious liberty. I think they're tightly tied together. The question of how to handle wedding vendors who refuse to facilitate same-sex marriages is one of adjusting, whether the adjustment is minor is the pertinent question, adjusting the boundary between public and private. But there is a limit to religious accommodation in a regime with a constitutional prohibition of establishment of religion. What religious people may not demand is the right to invade and direct the public sphere, to alter the delivery of state functions in order to force their views on non-adherents. And unhappily, The federal judiciary, which lately has been notable for its solicitude for conservative religion, is crossing that line. And so I'm going to focus on an extravagant expansion of free speech rights of public employees who have religious objections to the directives of their employers. And the cases I'll talk about, one is the Merriweather case, and the other is Kennedy versus Bremerton in the Supreme Court. And in each one of those, the courts have held that publicly employed teachers may exercise their rights of free speech and freedom of religion, even when doing so mistreats students. In both of these cases, despite a long-established rule of deference to public employers' need to control their operations, and in both of these cases, mighty efforts to accommodate difficult employees, the public schools lost the capacity to protect their students from misbehaving teachers. In each of these cases, the school tried to cobble together a solution that would give appropriate weight to each side's most urgent interests. And in each case, the court said, not good enough, the religious side has to be granted absolute uncompromising victory. It was oblivious to the countervailing interest. And so the language of privacy and autonomy was deployed to enable religious people to deploy state authority and harm their students. These are only two cases, but they come from high federal courts. One of them is from the Supreme Court, and their similarity of approach and resemblance to other recent treatments of religious liberty is reasonable cause for alarm. Now, others have talked about the Merriweather case, just a little bit more about the facts. Merriweather teaches philosophy at Shawnee State University in Ohio. The school's had a policy since 2016 of requiring faculty to respect students' pronouns. He called on a student and responded to a question from Doe with, "Yes, sir," and the student approached him afterward and explained that she uses feminine pronouns, and he refused to use her pronouns, and they both reported it to university officials. There was some negotiation about how to resolve this. Just a bit more about the facts in this case, the magistrate judge found that the student dreaded participating in his class but felt compelled to do so because he graded students on participation. And she experienced serious psychological strain and distress, including an exacerbation of her gender dysphoria. The school obviously has an interest, a pedagogical interest, in avoiding these consequences. He said, because of his religious beliefs, he does not regard this student as female and that he should not be compelled to say things that he disbelieves, metaphysical positions that he believes are false. In his papers, he doesn't discuss the harm to the students, in fact, shows no awareness of it. Now, this seems to me to be exactly the kind of situation that calls not for adjudication, but for ad hoc negotiation, where we should try not to follow any abstract principle, but to accurately discern the interests at stake and cobble together an approach that gives some weight to the most urgent of those interests. And that was what the school actually proposed. The school said, in an email to Merriweather, every student needs to be treated the same in all your classes. So you could refer to, they said, why don't you refer to students by either first names only or last names only without using gendered titles for any of them? That would treat all students equally. And his district court complaint explains why he rejected that accommodation. He thinks that using students with titles, Mr. or Miss, fosters an atmosphere of seriousness and mutual respect that is befitting in the college classroom. Now, that's not a religious belief, that's his belief about pedagogy. Of course, the seriousness and weightiness of honorifics wouldn't be available to the transgender student. He was insisting on his right to single out this student and treat her worse than everybody else. She would only be addressed by her last name. Everybody else would be addressed by Mr. or Miss. The Sixth Circuit rejected this compromise. It said it'd be hard to comply, impossible to comply with. No Mr. or Ms., no yes sir or no ma'am, no he said or she said. Now, I think that it's not, I'm a teacher, is not all that hard. The assertion that it is impossible to say yes rather than yes, sir, is unworthy of response. Referring to somebody by their name rather than by a pronoun hasn't got derogatory implications. It's actually a good way to communicate that the student's contribution to the discussion is valued or recognized, or at a minimum, and this matters, that the teacher remembers the student's name. So, but the Court of Appeals said that this is a matter of public debate, and that professors are not to have an orthodoxy imposed upon them about matters of public concern. And the language with which one addresses a student is a matter of public concern. Well, racism and sexism are ideas. Those who proclaim those ideas are engaged in speech about matters of public concern. The court says that Meriwether's speech also relates to his core religious and philosophical beliefs, and that gives his free speech claim more weight. Well, American racism is often reached for religious arguments. Suppose a professor believed what the Supreme Court once attributed to the framers of the Constitution, that African Americans are beings of an inferior order and altogether unfit to associate with the white race. Well, the professor might think, black students are not entitled to Mr. or Ms. Other students are. Is that protected by free speech? Or suppose that he was to say to specific female students during office visits that it is his opinion, just a general opinion about the pedagogical process, that female students tend to perform better when they make themselves sexually available to the professor. Matter of public concern. So I'm not going to get into the questions that Carolyn Corbin very capably addressed about where the line is. I just want to say that the line that the Sixth Circuit drew about you just can't have any constraint on professor speech about a matter of public concern can't possibly be correct. And that the school actually proposed to do it right. The other odd move of the Sixth Circuit opinion upholding Meriwether's claim is that the court said that, well, there wasn't any harm here because the student got a good grade in the class. And so this means that there is nothing that the school can do to prevent harm to students until the harm has already happened and can be proved in court. Again, this can't possibly be the law. The other case that I want to talk about here is Kennedy versus Bremerton. For years, Coach Kennedy led his players in prayers. When the school district learned of this, it told him that he was not to lead prayers with students. After the athletic director told him this, while the athletic director watched, he led a prayer out loud holding up a player's helmet as the players kneeled around him. And while riding the bus home with the team, he posted on Facebook that he thought he might have just been fired for praying. In other words, his first response when told or reminded of the school's policy was to deliberately and openly defy it and then anticipate conflict. Well, the school district didn't fire him. In fact, it never fired him, and the statements to the contrary by the Supreme Court are just false. It sent him a letter instructing him that he had to do it separately from students, and he hired an attorney who sent the district a letter claiming that he wanted to be able to privately pray on the 50-yard line, and he said, to the extent that students voluntarily choose to join Coach Kennedy, the district must not discriminate against, prohibit, or interfere with student-initiated religious activities. Well, the district obviously understood that this puts the students in an awkward position that it wanted to prevent. I'll talk more about that in a moment. But it wanted to figure out a way to accommodate him. I mean, it didn't absolutely reject his claim. It said, maybe we can work something out. He refused to so much as talk to them. He never came in after numerous requests or contacts. He only communicated to the district through the media. Instead, he began a tour of the media claiming that he was a victim of religious persecution. He gave a newspaper and television interviews. He appeared on Good Morning America and Fox News. Spectators at one game swarmed the field to join his prayer, knocking students down. School officials started receiving hate mail and threats. Several of them quit because they feared for their physical safety. So then they suspended him with pay. He sued, claiming that his rights of free speech had been violated, and the Supreme Court ruled in his favor, and it made many of the same moves as we saw in the Merriweather case, distorting the record, minimizing the harm to students in order to vindicate the religious claim, arguing that there was no direct evidence that the students had been coerced, that any students had been coerced to pray, and that the school had no legitimate interest that could interfere with what they called his personal private prayer. Well, but it's clear that he wasn't interested in personal prayer. He was interested in praying with the students. He told a newspaper later that the reason why he was litigating this was for the sake of helping these kids be better people. There's lots of evidence in the record that one parent complained that his son felt compelled to participate because he felt he wouldn't get to play as much if he didn't participate, and others said their children participated in the prayers only because they didn't want to separate themselves from the team. The coach has unlimited discretion about who plays. Students who don't play won't get full scholarships. The district court, whose findings of fact the Supreme Court was obligated to accept unless clearly erroneous, which they did not find clearly erroneous, said that there was exactly the kind of vulnerability to pressure that makes the Establishment Clause vital in the high school context, that the students felt under pressure for the sake of their athletic careers to participate with the coach. It is revealing that when the coach stopped leading the praying, no students voluntarily did it. They had a clearly kind of constitutional right to do it. They only did it when the coach was there. And now the position that this puts students in is a harm that is regarded as such by the Establishment Clause, because the framers regarded compulsory prayer as the core thing that was wrong with establishment. Because it produces hypocrisy, it produces empty, meaningless religion. This was a concern of Madison and Jefferson, many of the framers. It's not only non-Christians who are going to be offended by this way of carrying on. Some Christian students are going to be unwilling to join the coach's prayer because they regard it as a distortion of Christianity. If I'm allowed to say, the pertinent source here is somebody said, do not be like the hypocrites, for they love to pray standing in the synagogues and on the street corners to be seen by others. But when you pray, go into your room, close the door, and pray to your Father who is unseen. Now that was Jesus of Nazareth, and Coach Kennedy is entitled to think that Jesus was confused about what would make students better people. He's allowed to think that. We have religious freedom in the United States. But the school is no longer permitted to hold that its authority can't stand behind the proposition that Jesus was confused about this. And you see the same moves as in Merriweather. The court says, well, there's no evidence that students were directly coerced, no record evidence that students felt pressured to participate in these prayers. So once again, the state can't protect students from the risk of harm because the court says, unless the harm has already happened and can be proven in court, there's nothing that the school is permitted to do. In both these cases, what teachers do to students in public educational institutions while they are on the public payroll and exercising power that they have only because they're state employees is judicially deemed to be private and beyond state control. And both courts demand proof that students have actually been injured, disabling schools from preventing harm before it happens. In both cases, the state tried to devise a reasonable accommodation with its employee. In both cases, the court finds that inadequate. The employee is entitled to reject any compromise that gives any weight to the student's interests. In this new dispensation, even slight burdens on the religious are intolerable. Any demand that the religious think about an accommodation that matters, in which which anyone else matters is intolerable. Substantial injuries to the non-religious are minimized or ignored. It happens, and it's impossible not to notice, that the judges who decided these cases are themselves conservative Christians, and as members of that group win case after case, often on the basis of really weak reasoning, it's hard to avoid the suspicion that tribalism is at work. And in the context of adjudication, tribalism is a form of corruption, as much as if the judge were married to one of the parties. These decisions offer a distinctive vision of the appropriate response to religious diversity. The Kennedy Court cites a long constitutional tradition under which learning how to tolerate diverse expressive activities has always been part of learning how to live in a pluralist society. Evidently, part of learning how to live in a pluralist society is discovering that you've been bullied by a conservative Christian and there's nothing you can do about it. There's also a distinctive vision of religious identity here. A long-standing part of American disestablishment is that the state is supposed to be neutral with respect to theology. The state doesn't get to say what Christianity is. But in these episodes, the courts are embracing a religious vision, one that I disagree with and one which I think should be contested: the Christian as unapologetic sociopath.
Thank you. Shannon Minchie, please.
Yeah, go Andy. Yeah, that's good. Yeah, I guess thanks for hanging in there. I was the last person here, but yeah, we're still here. I just want to let y'all know, just as we're here at this conference, I mean, just to pile on to what Professor Nielsen was talking about, the Florida Board of Medicine just voted to ban all medical care for transgender young people, and they held a hearing where they only permitted those supporting the ban to speak and told all these young people who had come to speak against the ban, sorry, we're not, here's our email us. So this is the social context here is very real. I was also really surprised, but I'm happy that so many people are talking about the Merriweather case. I think it's a really important case, and it's really, really concerning. I was counsel in that case, part of the legal team in that case. The university, of course, was primarily responsible for defending their non-discrimination policy, but because I work for an LGBT rights organization, National Center for Lesbian Rights. We intervened on behalf of the student, Professor Merriweather's student, so we were an intervener defendant in the case, and I will tell you that even under what I think is a terrible Sixth Circuit decision, the Sixth Circuit did leave open the possibility that the university and the student could have prevailed on remand. I mean, they held that the Garcetti standard didn't apply, but under the more liberal Pickering standard, that there was no record. I mean, this was all decided below in a motion to dismiss, and that's what was in front of the Sixth Circuit, so there's really no record. They said, yeah, well, if the university can show that violating the non-discrimination policy actually prevented Merriweather from doing his job and actually caused harm to the student, okay, then they might prevail under Pickering. I firmly believe we absolutely could have done that. We were really upset the university settled. We had no ability to affect that or block that at all. We would have if we could have. I think we would have won. If you can just imagine, and I really appreciate what Professor Nielsen was saying. I mean, imagine trying to be a student where literally, like, your professor, every time you want to raise your hand and participate in class, is referring to you as the wrong gender. I mean, I feel like it's distracting at best, humiliating, devastating, in truth. I mean, I don't know how that kid got through that class. She did. But it took an enormous amount of strength and emotional resilience, and it took a huge toll on her. I mean, it's just imagine trying to do that, even as an adult, in a workplace. If someone's constantly referring to you as the wrong gender, it's just how can you function? And I really think that sometimes those of us on the advocacy side of this, the trans side of this, play into this too much. It's like if you're referring to somebody, I mean. Not to pick on you, Professor Duncan, but if I refer to you as he or Mr., I'm not affirming you. I'm just being normal. Like, why is it when a trans person is referred to by the right gender, we're like, oh, good, I'm going to affirm you? It's like, no. I mean, I'm a transgender person myself. I'm a transgender man. I don't want to be affirmed. I just want to be treated like anybody else. So just to say that. But anyway, so I also wanted to say that the one part of that opinion I do not necessarily disagree with, Meriwether, is that Garcetti shouldn't just categorically apply to all university professors. And Will, y'all filed an amicus brief on that, and I don't necessarily at all disagree with that, but that just begs the really threshold question of, did this school policy, did it compel speech? Does it implicate the free speech clause of the First Amendment at all? And the answer to that, in my view, is just no, absolutely not. I mean, requiring that a university professor refer to students when calling on them in class in a non-discriminatory way, that is a regulation of conduct. It's not a regulation of speech. The fact that when you call on somebody in class, you are literally saying words or using words, that doesn't transform that non-discrimination policy into a restriction on speech. I think, a university could, and they do, prohibit professors. Professors can't say, I'm only going to let men speak in my class. I'm only going to let people of a certain race speak in my class. I'm only going to let people who are Christian but not of other faiths speak in my class. I'm only going to let straight people but not gay people speak in my class. I mean, you could imagine, I guess, that some professor could say, well, you're compelling my speech, because in a literal sense, yes, not in a doctrinal sense, but in the most literal sense possible, yes, if you have to call on women, you have to call on students of all races, religions, sexual orientations, that's requiring a professor to utter words, and you could try to say that's compelled speech. But under the doctrine, no. I mean, very few people, I think, would say that constitutes compelled speech, as far as that's a legal term of art that's used in First Amendment case law. And if it did, we'd be in big trouble, because it would be very difficult to have any non-discrimination laws, since almost all human conduct of any kind, including discrimination, involves some element of speech. And the Supreme Court has been really clear about this principle. I mean, for a long time and repeatedly. Hang on. Lost my place there. Yeah, it's been clear that the fact that when a law regulates conduct, the fact that conduct involves speech or is carried out through speech, that does not transform the law into a regulation of protected speech that's then subject to strict scrutiny under the First Amendment. If you're going to rob a bank, you may speak the words, stick them up, but that doesn't transform a law against bank robbery into a restriction of protected speech. I think one of the most important cases here, and that one that should have been dispositive in Meriwether and similar cases, is the Rumsfeld versus Fair case back in 2006. We had some law schools challenging a federal law called the Solomon Amendment that required all law schools not to discriminate against military recruiters. I mean, the law basically said, hey, law schools, if you're letting other recruiters come on campus, you can't exclude the military, so essentially prohibiting discrimination against the military. And law schools tried to argue, they did argue, that the law violated the right to free speech, because they said, oh, well, you're compelling, we don't like the military's anti-gay policies that were in place at the time. We don't like, and if you make us allow the military to come on campus to recruit, you're effectively compelling us to send a message supporting that anti-gay policy. And they said, for example, we have to send out emails publicizing these military recruiters, and that's emails, that's speech, that's compelled speech. And the court correctly, in my view, rejected that argument out of hand. And here's the critical passage from that decision. The court said, the compelled speech to which the law schools point is plainly incidental to the Solomon Amendment's regulation of conduct. It has never been deemed an abridgment of freedom of speech to make a course of conduct illegal merely because the conduct was initiated, evidenced, or carried out by means of language, either spoken, written, or printed. Congress, for example, can prohibit employers from discriminating in hiring on the basis of race. The fact that this will require an employer to take down a sign reading white applicants only hardly means that the law should be analyzed as one regulating the employer's speech rather than conduct. And the court cites Justice Scalia's opinion in RAV with this very fundamental proposition. Words can, in some circumstances, violate laws directed not against speech, but against conduct. You can violate a conduct regulation through words. Compelling a law school that sends scheduling emails for other recruiters to send one for a military recruiter is simply not the same as forcing a student to pledge allegiance or forcing a Jehovah's Witness to display the motto, live free or die. And it trivializes those freedoms to suggest that it is. So the same is true for compelling a professor who refers to other students consistently with their gender identity to do the same thing for a transgender student as well. That is conduct. It is not speech. In the Fair case, the issue is about equal access of recruiters. In the Merriweather, it's about equal access of students to just being able to participate in class. The Supreme Court reiterated that principle very recently in the NIFLA case, NIFLA versus Becerra. I'm not going to talk about the facts in that case or anything like that, but there's a great line in that case written by the majority opinion by Justice Thomas that says there is a really fundamental difference between a law that regulates speech as such, like that regulates speech as speech, and a law that regulates conduct that happens to involve speech or that happens to be carried out through speech. I just think that principle applies in the most direct, unambiguous way to the policy in Merriweather. There's not a meaningful First Amendment difference between a policy that prohibits professors from discriminating when they decide whether to call on students, like, you know, they can't just say, I'm not going to call on women, or I'm not going to call on people from a certain faith, and a policy that prohibits professors from discriminating when they're deciding how to call on students. You know, Professor Koppelman, you made some of these points. A university, of course, they can prohibit a professor from referring to all female students by their first name and then referring to all male students as Mr., or from referring to white students in one way and students of color in another. That is just disparate treatment. It's just pure and simple disparate treatment. The fact that it happens, that the conduct at issue happens to involve like uttering words, does not transform a policy prohibiting that type of discrimination into a regulation of protected speech. And it doesn't matter that a professor may intend the disparate treatment to send a message about race or gender, but that doesn't transform the discriminatory conduct into protected speech either. So just in this very same way, of course, a school should be able to require that teachers refer to transgender students respectfully, the same way they do everyone else, using the pronouns that correspond to their gender identity, just like they do for everyone else. The fact that the conduct at issue literally involves words like using someone's name or pronoun or honorific, that doesn't anymore transform that policy into a regulation of speech than a law prohibiting an employer from saying, I'm firing you because you're gay. That's not a regulation of speech. You're not punished, in that case, you're not punishing the employer because of their views about gay people, you're punishing them for their discriminatory conduct. Similarly, when a professor does what Merriweather does, you're not punishing him for his views on sex, whatever the heck they may be, but for mistreating a student, for making it more difficult for a transgender student to participate in class because you're treating them differently than you're treating everyone else. I would submit, and here's what Professor Nielsen, I really appreciate what you were saying. It's only against a social background in which transgender people are severely stigmatized and demeaned. Their very existence is seen as controversial by some people, that there could be any question, I think, any real question about how to apply all this very clear, very well-established precedent to this issue. And last thing here is, I think it's helpful to look at this from two angles. Again, I'm really focusing on the compelled speech doctrine here. I mean, one is the argument that just by making Merriweather comply with the policy, that's a free speech problem because it's going to make other people believe that he's somehow making some kind of statement. And then the second one is that he intends to send a message by not complying with the policy. But under just the most clear-cut precedent you can imagine, neither one of those matters at all. The fact that a professor subjectively imputes some kind of expressive meaning to complying with the non-discrimination rule does not turn a regulation of conduct into a regulation of speech. I mean, a professor, for example, may strongly believe that men and women have different roles, that women really shouldn't speak in class, and that being forced to call on women in class forces him to send a message that he disagrees with. But under a controlling Supreme Court precedent, that subjective belief on his part makes no difference. It does not turn that case into a free speech claim. And it may be that a professor subjectively holds any number of possible beliefs about transgender people. They shouldn't exist. They're delusional. Their true sex is their birth sex. God created you the right sex, and you shouldn't try to change it. You can't change your sex. I mean, he may also feel that being required to use female pronouns to refer to a transgender woman is forcing him to send a message or going to make other people think that he believes something he doesn't believe. I think, in effect, it just kind of boils down to, hey, you may think you're a woman, I don't, and if I'm forced to refer to you by female pronouns, I'm being forced to send a message that I agree with you and I don't agree with you. But that is just directly analogous to the argument that the law schools made in the Fair case. As the court said, the schools say that if they treat military and non-military recruiters alike in order to comply with the Solomon Amendment, they could be viewed as sending the message that they see nothing wrong with the military's policies when they do. But the court was like, no one is reasonably going to think that just because you're treating military recruiters as you're required to by law, that you're somehow endorsing their policies. And nothing about having to comply with the Solomon Amendment prohibits you from saying whatever the heck you want to say about those anti-gay policies. Knock yourself out. Say it all you want, but you can't discriminate against those recruiters. And the same thing is true here. I mean, no one is reasonably going to think that simply by treating transgender students equally as required by law, that a professor is somehow then endorsing any particular view or opinion or belief about sex or gender or transgender identity or anything else. And I actually disagree with Professor Corbin on that, which I could talk about later maybe. But being required to treat students equally, and nothing about complying with that non-discrimination policy prohibits him from saying whatever he wants to about all these issues. Go for it. Say anything you want, in class, out of class. But that's completely separate from you having to treat students equally when you're engaged in the professorial conduct of calling on them in class. Now, just last thing, the Supreme Court has also so clearly rejected the kind of flip side of that, the argument that if a person wants to violate a non-discrimination law because they think doing that, they want to do it in order to send a message, that somehow transforms their conduct into protected speech. In Fair, the law schools argued that. They said they wanted to exclude military recruiters because they wanted to send a message. They're like, we want to express our disagreement with the military's anti-gay policy. And the court did not buy that at all. I mean, as the court pointed out, the mere fact of excluding the military, that conduct of excluding them, is not inherently expressive, either speech or conduct. The court said, an observer who sees military recruiters interviewing away from the law school has no way of knowing whether the law school is expressing its disapproval of the military, all the law school's interview rooms are full, or the military recruiters decide for reasons of their own they would rather interview someplace else. Just the conduct in itself doesn't send any inherent message. Same thing, absolutely true in Meriwether. If you're just an observer, you're seeing this professor refer to our client with male pronouns, you just know why he's doing it. I mean, maybe he's nearsighted. Maybe he doesn't like this person. Maybe he thinks he should use male pronouns for everyone. Maybe it's a comment on how he thinks she looks. Maybe it's an accident. Who knows? But the only way we know that he's intending, quote, to send some specific message by that is that he has to tell us, is additional speech explaining what he means by that discriminatory conduct. So back to Fair, the court said the expressive component of a law school's actions is not created by the conduct itself, but by the speech that accompanies it. The fact that such explanatory speech is necessary is strong evidence that the conduct at issue here is not so inherently expressive that it warrants protection. If combining speech and conduct were enough to create expressive conduct, a regulated party could always transform conduct into speech simply by talking about it. For instance, if an individual announces that he intends to express his disapproval of the IRS by refusing to pay his income taxes, we would have to apply O'Brien to determine whether the tax code violates the First Amendment. Neither O'Brien nor its progeny support such a result. And the same thing's true in Meriwether. Without the professor's explanation that he's refusing to refer to a particular student by female pronouns in order to send some particular message, we would have no way of knowing that he intended to send a message, much less what message he intended to share. I think that just the most shocking, misguided, dangerous part of that Sixth Circuit opinion is the court's complete failure to address, much less apply, that straightforward precedent. Nothing about fair in the case. According to the court, quote, Meriwether's, quote, mode of address was the message. His mode of address was the message. It reflected his conviction that one's sex cannot be changed, a topic which has been in the news on many occasions, has become an issue of contentious political debate. So under controlling precedent, that argument would not be accepted in virtually any other context. You know, if some professor wanted to refer to women the way women are talked about in The Handmaid's Tale, like Offred, you know, of Fred, of their husband's name, it wouldn't matter if the mode of address was the message, or reflected his conviction that men should be the head of the household. I mean, it is only in a world in which courts just unthinkingly share the view that the very existence of transgender people is controversial, would that opinion be written. I'm just going to say, last thing, I know I'm out of time, but that aspect, it's just such a gross misuse of state power to enforce a stifling orthodoxy, and that is the irony here. I mean, this is supposed to be a free speech case, but it is actually, by applying such an atrocious, egregious double standard, the court is actually just falling back unreflectively, without acknowledgement or explanation, on majoritarian social norms, and literally using the First Amendment to enforce a majoritarian orthodoxy that is very harmful to transgender people. Okay, I'll stop there. Thanks, y'all.
Thanks very much. I do have some questions, and I hope that we can have a little bit of a discussion and probably open it up to audience questions, I hope. I do want to talk a little bit about this Meriwether case because I found it very interesting as a First Amendment advocate. I mean, I have my own views on it, but, you know, if we're thinking about Garcetti and Connick and Pickerington and that framework where public employees have a right to speak on matters of public concern as long as it's as a private citizen and not as part of their job duties, and then if you satisfy that, you get to this balancing of state interests versus the interests in the employee speech. I guess my question is sort of goes back to Professor Corbin's hypothetical about, you know, an orchestra teacher. Does it matter what the subject is here, right? So we've got, you know, in Meriwether, my read of the opinion is he was teaching a political philosophy course. You know, should we start requiring syllabi as part of the record in these cases? Is that, and I would highlight part of the opinion on page 16. I don't have the reporter opinion. But the Sixth Circuit goes out of its way to say, of course, some classroom speech falls outside of the exception. They call it non-ideological ministerial tasks that would not be protected by the First Amendment. Their example is teachers who call roll at the start of the class. So I guess my questions are, does it make a difference what the subject matter is, and does that affect the academic freedom rights of the professor or the teacher? And secondly, is there, you know, how do we characterize this in terms of like ministerial versus, you know, your own viewpoint that has to be balanced? And I would open up to anyone who.
I could say something about this. So one of the things that happened during the negotiation was that Meriwether asked whether the university's policy would let him use the students' preferred pronouns, but put a disclaimer on his syllabus, I'm quoting, noting that he was doing so under compulsion and setting forth his personal and religious beliefs about gender identity. And the dean said that that disclaimer would itself violate the university's gender identity policy. Now, this was a philosophy class. His general beliefs about gender identity were within the scope of the scholarly enterprise. But on the other hand, that disclaimer in context would be understood by everyone to concern only this one student. And so it presents a harder case. Now that problem could have been avoided if he had adopted the solution of using only last names for all students, which had not yet been suggested by anyone at that point in the proceedings. I think that that would solve the problem. There just would be nothing for him to disclaim, and you would not have been presented with that problem. I do think that the university's imperative of just creating a good pedagogical environment for students would mean, for example, that in a political philosophy class, even if a professor firmly believes that African Americans are beings of an inferior order who have no rights, it would not be okay for him to put that on his syllabus. And that's a political philosophy.
Other thoughts along those lines?
I just think that the idea that it matters what the class is about is a complete red herring. I don't think it does. I mean, it wouldn't matter if it was a class that was about gender. It wouldn't allow professors to discriminate against female students in the class by being like, well, I'm not going to call them men, or I'm only going to call on men. It's just the subject matter of the class, I think, has absolutely nothing to do with whether that policy implicates free speech.
Example that I said, if the person says I am a man, I mean, the wording in the case, I'll say I'm paraphrasing because I don't have it in front of me, but is no reasonable person would have believed this person. I have some YouTube makeup tutorials to show you because if I tell someone I'm a man and you will use these pronouns, I don't understand what possible grounds any other person, much less a public employee in a classroom environment, can stand on to say, no, you are not. It's unbelievable to me.
You all, I don't want to monopolize this, but I think it's very difficult not to apply a double standard to transgender people. Like, when a student says, I would please refer to me as male or female, or as this student did, by the way, he had no idea when he referred to her as male in class whether she was transgender or not. He was basing that entirely on her appearance, I suppose. And, that's good luck with going down that path that you think you can tell who's transgender and who's not transgender just by looking at them. She just said, I'm female. She's not out. She was private. She was not, her transgender status is not something that she was public about. He based it solely on her appearance. But it's like for a professor, for example, to respect a student's their self-identified religion. I don't think we don't then go to the next question of does that mean he's agreeing that person really is a member of that faith, or that faith is true? No. So why do we even ask these questions about transgender people? It's for a professor to just respect someone's gender identity, whether they're transgender or not. There's no reason to then subject that to some kind of metaphysical analysis of like, well, is that by doing so, is he somehow assenting to a philosophical proposition that person really is this or that? Or it's just not the way we think about non-transgender people or identity in any other context. And I think it would be really helpful if we tried to stop doing that so automatically with transgender people.
I would say, I'm still here. So I think there's no for a lot of reasons, right? No, there's the argument that how you address students is really a matter of conduct that only incidentally affects speech, and therefore it doesn't matter what the topic is because it's a regulation of conduct. And then even if it's a regulation of speech, I think how a teacher addresses the student in class is pursuant to official duties, and therefore doctrinally would be government speech. And then even if you make an exception and say, well, what about academic freedom? Academic freedom in class is about discussing your area of expertise in the classroom. And so all of these professors and teachers claiming the right to misgender and invoking academic freedom have seriously misconstrued exactly what it's protecting. It's protecting the exploration in the classroom of their area of expertise, and gender identity is not their area of expertise. I could go on, but I think the answer is no, no, no.
Well, and the reason I asked the question is because of the doctrine, really, and the way that the ordinary job duties and the case law that says it should be viewed practically and all of those things. And so I was just trying to sort of press on whether it mattered what the topic at issue was. But I appreciate all of your points. Are there questions from the audience that we can address?
Oh, thank you. Okay, I have a bunch, but I'll just ask a couple. Caroline, it's Jessie Hill. I don't know if you can see me, but yeah.
I recognize your voice.
Okay. I guess maybe this is implicit in what you said, but it just seems like your doctrinal approach then also assumes that like don't say gay laws and critical race theory regulations and so on are okay, right? And I'm just wondering if you could speak about that doctrinally, and is that at all in tension with the normative approach that you take to the question? And then just one other quick question for Andy. Should there be a de minimis exception to free exercise or free speech claims or something along those lines, given your view that some of these disputes just should not sort of rise to this level, and maybe the substantial burden, some sort of sense of substantial burden is what we're grasping for, but I'm wondering if that's what you're getting
Say
at.
more about what you mean by de minimis exception for whom? De minimis works against the state or against the plaintiff? You have to tell me more about that.
The plaintiff. So does the plaintiff have to rise, make a certain level of showing of injury to, is that what the problem is here, basically? Injury to the constitutional interest or right involved?
Can I go first?
Please. Yes.
Yes, Professor Corbin, please go first.
Sorry, okay, Professor Hill's question is a really good one. I seem to have boxed myself in when it comes to bans in the classroom that are what I would consider more problematic, like teachers may not teach critical race theory, Florida's Don't Say Gay law, which says teachers may not discuss sexual orientation or gender identity. And so, as a doctrinal matter, I think those claims are hard because of Garcetti. I mean, the doctrinal rule that speech pursuant to official duties is government speech and therefore completely under the control of the government is an actually very problematic doctrine. And so I actually think that the fact that it makes it okay to ban misgendering is one of the silver linings of a really problematic doctrine. But I think it can be an issue when what the school is doing is more harmful. Having said that, I don't think that doctrinally there's complete foreclosure on challenging these laws. Partly because I think the Supreme Court, at least we saw in Kennedy, is willing to say not everything that goes on in school is pursuant to official duties. And second, I'd also point out that while the teachers may have no hope of bringing a free speech claim, the students may have one, right? So I think their free speech is both about the right to speak, but especially about the right to receive information. And I think there are certain free speech limits on what the government can do when it's regulating in the classroom. And if it's regulating for partisan reasons or based on hostility rather than valid pedagogical reasons, I think there may be a free speech claim there. There may also be equal protection claims. So again, as a doctrinal matter, Garcetti and the rule that speech pursuant to official duties is government speech does definitely make it harder to challenge those cases, but they don't make it impossible. And that's just the doctrinal explication. I think as a matter of normative law, they clearly don't have the same problems that misgendering do, right? They are not harming students. They cannot be considered anti-knowledge. They actually sort of further, right, if you're thinking about academic freedom, and it's a history teacher talking about the history of race that is in their area of expertise, and it furthers discussion, it furthers our knowledge, it furthers our inquiry to have that in the classroom in a way that misgendering just doesn't.
So the question of what counts as a burden on religion is one of the most vexed areas in free exercise law. because when we ask, well, how much of a burden is this on your religion, we are inquiring into the theology of the claimant and trying to sort that out. And that's something that the state generally is not allowed to do. We're not allowed to say, well, you think that this is a heavy burden on your religion, but we, the state, have looked at your religion, and you're just mistaken about your religion. It's just not that heavy a burden on your religion. You're just not allowed to do that. So there is a literature of people trying to figure out basically substitutes for that, and none of the substitutes fit all that well because they're substitutes. So that's why you can, for instance, ask, well, how heavy is the secular consequence? In this case, I guess if I were on a school disciplinary board and Meriwether continued to insist on behaving this way towards students, I'd fire him and thereby clarify the question of whether there's any serious secular consequence. I'm not inclined to dismiss him as de minimis. Just on the question of, I guess I'll take on the question of, don't say gay and all of that. There is this general presumption in Garcetti that the state gets to decide what the job description is, so the state gets to decide what the curriculum is. So I don't think that the Garcetti claim will work. There are other constraints on the state's ability to structure its pedagogy. Part of the state's claim in Brown versus Ford was, look, part of what we're trying to teach our students is that the races are to be separated. And we're not going to be able to teach that thing that we believe if we aren't able to separate them. And it turns out that the 14th Amendment overrode that. I think that the idea that students need to be ignorant about the status or even the existence of certain minority groups that are protected by the 14th Amendment raises a 14th Amendment problem.
I was saying, I think if you close the Garcetti loophole, you're totally screwed from an academic freedom perspective for in-class instruction, including, I think, you totally lose Florida cases. And Florida is definitely arguing that Garcetti, in fact, doesn't. Garcetti means there is no academic freedom protection of faculty. It's entirely government speech, what occurs inside the classroom. And if Florida's right about that, they, in fact, should win. And I think they can't be right about that if we're going to preserve academic freedom, which means that we have to take Hartop much more seriously as trying to say, look, there's going to be some important First Amendment interest here for a state university professor operating in the classroom. I think the better path forward is to try to think about which Hartop v. Meriwether recognizes, is there some administrative speech that the university can quite reasonably control. So there's some things, for example, they should be able to tell you should be able to put on your syllabus. And I think if we take that path and we can have a serious conversation about, well, look, how you refer to students in the classroom, does that count as administrative speech or is that substantive content of the class, for example? And I think there's very good reasons to think that ought to count as administrative speech as the consequence is capable of being regulated by the government. But that doesn't require that you totally then throw out Garcetti from this perspective. I think then it's enough to just be able to say, look, you have robust protections here. This is the little carve-out on the side. I think the far more disconcerting aspect of what the university had done in this context is the argument over what goes in the syllabus, which we didn't talk about really. But there is a sort of additional dispute between the professor and the university here about what he was allowed to say on the syllabus itself. And there, I thought the university, and if you take the university's position on this, it has some pretty serious effects on the ability of faculty, for example, to be able to talk on the syllabus about educational things. There's a whole bunch of stuff that the university can basically convert your syllabus into governmental speech as well, which would be quite troubling.
So Keith, could a science teacher say, it's been my experience as a teacher that women just aren't able to handle the material in my class, so I want to warn any female students who are thinking about enrolling in this class that you really should think about this. This is not a class for girls. Could he be stopped from putting that on his syllabus?
I don't think you want to put that on the syllabus, right?
But suppose the teacher does.
No, I agree.
I don't, but
no, I think there's separate from the question about what you can and can't put on the syllabus. There's still questions about what kinds of things we would properly characterize as harassment. There are real questions about how academic freedom and harassment all interact. I have real concerns about how aggressively a lot of universities are interpreting the harassment policies relative to in-class speech, for example, as well as affects extramural speech. But I think that kind of example is one that starts bumping up against where I think appropriate harassment policies is what would take care of it rather than something else.
Yeah, I just think the key thing is to not, there's there's such a double standard. I know I'm like a broken record on this, but there really is when it comes to changing our stuff. But Professor Whittington, I agree with what you said about Garcetti. It's not all or nothing. I just want to say we have a pending federal lawsuit right now challenging Florida's Don't Say Gay law on equal protection as well as some First Amendment grounds. But I think the equal protection is the stronger argument. The law says that there can be no instruction K through 3 on sexual orientation or gender identity, which is facially neutral. However, it is applied. We have a selective enforcement claim, equal protection selective enforcement claim, because that is not being applied to restrict any classroom instruction about heterosexual parent families or transgender people, but only about LGBTQ people and issues. So, I mean, we're not by any means without a basis to challenge that law. It's really insidious. I mean, it's a really insidious law.
And I'll say
I want to just mention with the syllabus, and here I really want to bring in Professor Nielsen's really crucial point that you can't overlook the power dynamics of what's going on. And to put that in free speech terms, I would like to just remind that the captive audience doctrine, I think, has a role to play in these discussions that have not been sufficiently highlighted. And under the captive audience doctrine, there's an idea that even private speakers, purely private speakers, might have to curtail their speech if it's inflicted on people who can't avoid it in certain circumstances. And that's why I want to really emphasize the fact that students in class are a totally captive audience. They have to be in school. They have to be in that class. They probably, if it's young students, they may not even have a choice of the professor. Or if that's the only professor offering the class, they have to be there. And if the free speech doctrine can make room for the right not to hear certain stuff when it involves purely private speakers, then I definitely think there's room in the captive audience doctrine when you're talking about captive students and a teacher who is not purely private but a representative of the government.
Well, that's got to be captured by Germain's doctrine, not just captivity doctrine, right? Because if the government comes in and tells me
captive audience doctrine, yeah.
I said it's got to be dealt with though from Germain's perspective rather than from simply saying what's a captive audience, therefore the government can control everything you say. That if I say, look, as a constitutional law professor, I ought to be able to offer a perspective on cases, and some students say, wait a second, I'm a captive audience, I don't want to hear your perspective on those cases. I can quite reasonably say, no, that's crucial to the subject matter of the course, and I ought to be able to teach it. On the other hand, it's quite reasonable for the students to say, but I don't want to hear your views about Donald Trump in my class particularly, which has nothing to do with the subject matter of the class, right? There, the captive audience concern is a very real one.
Yeah, I don't know if we're disagreeing with each other. I was just trying to say, yeah, part of it is Germainus, like students have to hear about U.S. history in U.S. history class, and they're captive precisely for that reason. But again, if it's on something completely unrelated to the actual classroom and a justification for the government bringing them in to hear it, then I think the captive audience doctrine does come into play. So I don't think we're disagreeing with each other.
We have a Free Speech Act happening right now. What is it? Read them. Okay, no.
I'd like to get another question.
Okay.
Just let me just speak to this. Let me just say that some people know that there is a controversy over the editor's decision to publish an article in this volume that has nothing whatever to do with today's symposium. And I think that as long as people are simply putting signs up that is consistent with university policies, to the extent that anybody seeks to disrupt the actual program, that raises other issues. But as I look at what's going on at this point, whether this is directly or even indirectly related to today's program seems to me to be separate from what we do. if people want to talk about the other controversy later on.
We stop talking about the conference and start talking about
okay, so
that's what disrupts the conference.
okay, so
Okay, I know, he's got a question.
Yeah. We move the audience question.
Yeah, this one is for Andy and the limits of what did you say? Sociopathic teachers, Christian teachers who want to pray on the 50-yard line. So I've got a couple of really not hypotheticals. One is a case from about 30 years ago that I don't think made it out of the district court. And this was a case of a Christian teacher in I think 4th or 5th grade, so elementary school, who brought his Bible into the classroom, didn't offer it to the students to read, but during the quiet reading time, they had 15 minutes where the students could sit down and read their book. The teacher would open up his Bible and read his Bible in front of the students there during quiet reading time. Someone complained, he was told to remove the book, the case got litigated. I think it only went as far as the district court, I think it was out of Colorado, and the court held the Establishment Clause justified the school in censoring the teacher's quiet reading time in his classroom. And the second one does involve Bremerton. As I recall the facts of Bremerton, he was ordered not to pray anywhere where students would be able to see him praying. So it wasn't just on the 50-yard line. If he had prayed over lunch in the school cafeteria, he would have been violating that prayer. Now, his facts have a lot of baggage with them, so let's just set that aside a little bit. And imagine, again, in a public school, a teacher takes their lunch into the cafeteria and every day prays over their lunch. In the presence of students, students can see what they're doing, they bow their head, maybe clasp their hands in a symbol of prayer. Do you think that is an example of a sociopathic teacher, Christian teacher praying in the public schools?
No, in neither one of those cases is he exerting coercive power over students to compel them to join him.
Even though they might see him doing this and teachers in his class, students in his class might say, oh, I should pray over my lunch too, because maybe he'll give me a higher grade. It's the kind of exact same argument. I should join him in prayer because he'll give me a little more playing time.
Well, history and context matter here, and the fact that in the Kennedy case there had been a history of him leading prayers, and he clearly indicates that it's his intention that students continue to join him. He told the press, I'm doing this because I want to teach these students to be better people, is entirely different from a situation where it is clear that the teacher is simply exercising his own religion. The guy reading the Bible during quiet reading time, I have no trouble at all saying that he's got a right to do that, or a teacher has a right to wear a headscarf or a yarmulke. The issue is the coercive pressure on the students and whether that is something that the school has a legitimate interest in preventing.
So just a little bit of a move now. We go to a different public school, a different coach without all this baggage. And at the end of each game, the coach wants to kneel at the 50-yard line and pray to thank God that the game was played right and there were no injuries or whatever the case may be. He doesn't invite anybody to do it. He doesn't go to the press. He just quietly prays at the 50-yard line, but he's kneeling.
Yeah, it depends on the pressure on the students. So
students see him.
One thing the court cited as evidence that Kennedy was being persecuted was he said that he was willing to pray at a time when the students just weren't around at all, when they'd gone back to the locker room. What the court's opinion does not say is that he said that for the first time in a deposition during the litigation. He never offered that to the school district. The court is so invested in a narrative of persecution that it gets to do violence to the facts because it's the Supreme Court.
So your focus is very, very specific on these particular facts and this particular coach.
Well,
it wouldn't extend to other coaches with less baggage, let's say.
Well, I take it that if football coaches henceforth say, I'm going to pray in the presence of students and they can join me if they want to, all over the United States now, football coaches get to do that. So it's not just about this one case. This is about major change in Establishment Clause law all over the United States, and students all over the United States being taught that Christianity is really a hypocritical sham.
I won't go there. That's for
It's
another
what you
time.
do if you want a football scholarship, even if you're Jewish. You join the Christian prayer because your family. This is your parents' retirement money. You got to do this.
By the way, the caution Kennedy, the school did say he could pray at the 50-yard line after the game, but he should just wait a little longer when the field was more clear. So it was, the school worked really hard to try and find a compromise with them. And he rejected them all because, as Andy keeps emphasizing, he really wanted to lead prayers. He didn't want to just pray himself. So I think that's important to acknowledge as a matter of actual fact.
We have time for another question, or do you want to?
I'm gonna go against my daughter's best wishes and ask a question. This was fantastic. I really learned something today when you move this from free speech to conduct. And as a 38-year professor and the chair of the RTP committee for 15 years, I'm curious in the Merriweather case whether there was any disciplinary actions on campus taken. Now, granted, I come from Southern California State University, and we have conduct policy and ethics for professors. And in this case, this is an issue that would have been brought up during the RTP process. And it's an issue in post-tenure review that would have been brought up. And we would have seen this not as a matter of free speech, but clearly as a matter of abuse to a student. So I'm just curious as to whether there is any of that in the background prior to that making it to the courts.
The administrative consequence was that he was given a written reprimand and warned that further corrective actions were possible. That's as far as it got administrative.
Definitely, the university treated it as part of their conduct regulation, their anti-discrimination policy. Yeah, he was the one framing it, as a speech issue, and yeah.
I'll say I think it's a really interesting question. What actions qualify as actionable under a First Amendment retaliation claim about whether the warning letter or would have been sufficient, or the warning letter plus the the threat of additional actions, and really I think the applicable test is whether it would chill an ordinary speaker to be subject to those restrictions. So I think it really does matter what the consequence of it was.
Well, I mean, I think the university did not dispute that it was trying to get him to stop doing what he was doing. The university defended on the ground that it legitimately had an interest in getting him to stop treating the student like this.
Well, thanks very much. This has been a great discussion. I will say Jonathan Etten, please.
Andy, didn't mean to cut you off. I just wanted, on behalf of the institution and as the faculty advisor to the law review, this is wonderful from my standpoint. I get to stand up here and bask in the glory of what the students have done to pull off such a terrific program all day. So I want to first single out Kennedy, who has really carried the ball on this program. And also Merit Salath, the editor-in-chief, who has done a terrific job. And I think she deserves a big round of applause as well. I would also say, I will say something as well about Eric Seiler, who unfortunately had to leave because he needs to go to a funeral out of town. But I think our speakers can attest that their arrangements have been made infinitely smoother because of Eric's terrific work. And so I think we ought to give Eric a round of applause so that he can see it on the tape. I also think we need to thank the Frank Stanton Foundation and the U.S. District Court for the Northern District of Ohio, the funders of this program, without which we could not have pulled this off, at least in this way. So thank you to them. And finally, on behalf of the law school, thank you to all of our speakers on this program and this morning. I've been around here a long time. This is one of the best programs the Law Review has ever put on, and it is because of our speakers that things have gone so well. Thank you very much. The video of today's program will be online in the next week or 10 days, depending on how quickly the IT folks can get things cleaned up. And I will let people know what the link is when it's available. For our speakers, I am looking forward to the manuscripts that will be in the issue, and I know that Kennedy and Merritt and the other people on Law Review are looking forward to that also. So thank you all. Have a safe trip where you're going, and we'll look forward to another successful program next year.
Just an announcement for those attending virtually. On the screen, you'll see where the link is to obtain your CLE for this program. Please complete the evaluation link in the chat box. It must be completed by October 31st at 5 p.m. and the temporary activity code is 459656. It should appear in about 30 days. Just a reminder that that link is in the chat. And it must be completed by October 31st at 5 p.m. This will stay open for a few more minutes for you to access that link.
Yeah, I would ask her. I think she's probably the best person.